Good morning. Good morning, everyone present here. Welcome to the final round of the 22nd TSV Memorial National Football Competition 2025. May please the honorable team number 135 represent the petitioner and team number TSV 103 represent the respondent for the case Akku and Esro versus Union of Iowa and Anandra. The petitioners TSV 135 apportionment of each speakers including represents speaker 1 20 minutes, speaker 2 20 minutes, represent 5 minutes. The respondent TSV 103 apportionment of each speakers including represents speaker 170, speaker 220 and represent 8 minutes. Council 6 function approves that. So, like, warm greetings to the bench. Warm greetings to the bench. Please on that the council is aware on behalf of the bench in the back of SR and SRW was giving opinion. The council seeks permission to address the bench collectively as your lordship. Much obliged, your lordship. Would your thoughts prefer a brief consider facts? Much obliged, your lordship. Your lordship tries to spread across the state and work around in the country. So the customary practice, the marriage happens to be practice of flying and here, a centennial married couple as per these customary practices. And company is 15 years. Later on, company became president and a social welfare officer reported this incident to the police. Police arrested him on the charges of penetrative sexual assault, your lordship. On the other hand, the High Court here dismissed the petition, which is why we adopted the application requesting for the termination of pregnancy of Carly, citing and moreover, the mother has refused for the application function. Apparently, these applications were denied alongside their being denied by the local courts. And on the other hand, under the existing criminal justice proceedings executed against Muna, a preliminary assessment and a special investigation report, they sought to decide the manner of the proceedings election. In the light of these results, suggested that the trial to the accused should be the children's book. However, Dr. Shukala has been objected to this and even speculates to writing an article suggesting that outlaw should not be tried under the juvenile law. Here, a petition was filed by the father of Muna and a son W, which challenges the constitutional validity of the Post Act and juvenile justice laws as violating the community customs and private rights. They also challenge the process of seeking social investigation and preliminary assessment. And moreover, the arbitrary denial of bail to Muna. The High Court of Tukkana dismissed this petitioner and the petitioner proudly abused his order under Article 1 for dismissing the Constitution of India. Dr. Shukla has also moved to the order seeking the termination of pregnancy of families, requesting for marriage of over tribal population should be aligned with the Special Marriage Act. And thirdly, transfer all cases related to this matter to the High Court of Govt due to constitutional concerns in law. If you are not satisfied with the facts of the case, the Council seeks permission with the statement of much obliged, Your Lordship. The issue here is fourfold. Firstly, that the Protection of Children from Sexual Offences Act 2012, which treats the Sexual Act of Marriage as a violation of law, is constitutionally valid. Secondly, when a Dr. Shukala clearly the instant matter lacks gold standard. Thirdly, whether the process of seeking a social investigation and preliminary assessment report under the Juvenile Justice Act 2015 vitiate the rights of the accused in a criminal process. And lastly, whether the marriage for all tribal population within the country of India should be made aligned with a special marriage. Your Lordship, Council number 1 will be dealing with the first issue, and the last issue will be dealt by the Council. The Council seeks permission to begin with the first issue. Much obliged, Your Lordship. Your Lordship, first issue, whether the Protection from Children from Sexual Offences Act 2012, which treats the Sexual Act of Marriage as violating of law is constitutionally valid. Your Lordship, its provisions are unconstitutional. The Council would like to place your attention on three main points. Firstly, applying these provisions to cases involving minors within marriage constitutes a misapplication. Secondly, the violation of Article 14 of the Constitution. And thirdly, the violation of Article 21 of the Constitution. Your Lordship comes to the first contention. The Council would like to call the attention of the primary objective of the Govt Act 2012, which states that it should safeguard enacted to the safeguarding children from sexual exploitation, harassment, abuse, and as well as ensuring that the child's best interests here are protected. Your Lordship, applying these laws to the case of sexual intercourse within marriage, this aligns with this very original purpose of the Act, Your Lordship. The Act never intended to bring romantic sexual affairs within teenagers under its guise, and this was observed by the court in Atul Mishra versus State of Uttar Pradesh, 2023, ASC 132309. Lordship, this very enactment was brought to protect survivors and victims of child abuse. But this itself has become a tool to abuse the romantic relationship and marriage and these customary practices, as observed by the court in Vijayalakshmi and Ananda versus State in Ananda, 2021, 1 MNW CR 252. Your Lordship, the primary objective of that here itself is not satisfied by applying into the sexual intercourse within marriage. Your Lordship, rigors of the tax should not be applied to couples who have sexual intercourse within marital context. And moreover, what is the possible consequence here? What the most probable consequence here is the wife would be suffering. She has no physical or financial support from her husband, as in the instant matter is currently suffering and languishing in jail, Your Lordship. And this was recently observed by the court in Govt versus State of Odisha, 2022, and Lifelong Odisha 29 years. Now the council would like to warrant the attention of honorable lordships to the very fact that no offence here has been committed by the accused here now. The accused here is charged with Section 3 of the POCSO Act, which is Parentage of Sexual Assault. Your Lordship, as per Webster's dictionary, assault means a threat or an attempt to inflict offensive physical contact or bodily harm on a person that puts the person in immediate danger or an apprehension of danger. So, Your Lordship, and moreover, the court in the case of Brunswick Rumsey Bio versus State of West Bengal 2021 SEC Online Calculator 2470 observed that penetration.
If you may pause there for a moment. Does this act envisage any kind of exemption to any categories of people? Like, for example, the tribals, or so as to take note of the cultural and social practices of certain communities. This is a statute which applies across the board to everyone equally. As long as no exception has been provided for in the statute itself, or that the legislature does not intend to provide an exemption, how can you at this point of time contend that certain categories or certain types of activities are exempted? On what basis would you say that?
Your Lordship, indeed, as per Your Lordship's statement, TAF does not provide any exception as to tribal or customary practices. The council has imposed its honorable bench, stating that the main contention is that this blanket approach itself of the provisions of POCSO is violation of the constitutional and fundamental right guaranteed to the accused here. And moreover, the fact that they belong to a tribal community and the marriage happened through the customary practice should be considered. The council would like to draw the attention of the court to the fact that
we have another problem. This is a criminal offense that is being made. It's a criminal offense. So when it comes to the criminal offense and the categorization as just the age of the person or age of the victim, certain categories of people who fall below a particular age are protected by this. When it comes to the criminal statute, can there be an exception based on custom, social practices, or community status?
Your Lordship, the council would like to draw the attention of
If you look at it, even in the code and the code of criminal procedure, and these are this. All but across the board application. It's a secular administration in a sense. So, can you say that there has to be some kind of accommodation to practices which only violate the criminal laws in the country? Merely because they belong to a particular social group.
Your Lordship.
How do you base it as a problem?
Your Lordship, council would like to first draw the attention of the court to the fact that tribal community here itself should be considered as a separate class. And they.
Why for criminal law? Why with respect to criminal law application is the case?
Your Lordship, the council is coming to the point. So they should be considered as a separate class. And under Article 29, they have the right to protect their fundamental or distinct customary practice should be protected. And secondly, Your Lordship, the court in the case of States of Nagaland versus Rattles in AR 1967 SC 212 has recognized that tribal communities are not governed by the same legal norms as other general population. So here, the court has upheld that therefore criminal procedure code cannot be applied uniformly to these regions. The council is contending that the same rationale should be taken by this honorable court, Your Lordship. And therefore, these provisions should not be applied uniformly to tribal communities. And moreover, this honorable court in recent times have shown sensitivity to such cases. If you take the case of Dandapani versus the state, 2019 SEC Online by the 20736, commenting case number 8, Your Lordship.
When the statute does not provide any exceptions, how can the court grant a relief?
Your Lordship, the statute.
In such case, you have to challenge the provisions of the statute.
Indeed, Your Lordship, the council is challenging the constitutional validity of these provisions of POCSO, which criminalizes the sexual intercourse within life.
Which are the provisions you challenge?
Your Lordship, the accused here is charged with section 3 of POCSO, which is penetrative sexual assault. And section 4 deals with the punishment, and we are also challenging section 5, aggravated penetrative sexual assault, and the whole chapter, Your Lordship, which criminalizes sexual intercourse here between married minor couple.
And what is the main ground of challenge?
Your Lordship, the main ground here is that the fundamental right of the accused here is violated by the application of these provisions.
Which fundamental right?
Article 14 and Article 21, and the tribal community are also guaranteed the right under Article 29 to protect their visiting customary practice. Your Lordship. And Your Lordship, as a counsel who is contending, if Your Lordship please refer to compendium case number 8, K. Dattapani versus State, 2019 SEC online 20766. This article would set aside the condition of an impulse in a POCSO case and recognize that practice in Tamil Nadu where a method unmet marriage ends. And this same rationale has been followed by multiple benches throughout India, Your Lordship. If we take the example of Wonder POCSO versus State of Meghalaya, 2020 SEC online May 390, the case is adjudicated the same. And recently, the case of Govt versus State of Odisha, 2024 Live Law, Odisha 29, the court recognized that tribal communities have unique customs regarding marriage and sexuality, and criminalizing these practices causes widespread injustice.
Yes, for example, let us leave alone their marital customs and their family relationships. Let us come to the very basic question of their food practices. They usually catch animals from the wild, like for example, wolves, tortoises, etc. Wildlife Act prohibits it. If they catch a bull or a monkey or tortoise, they are subjected to criminal proceedings. If that is so with respect to their food practices, why should there be an exception when it comes to marital aspects, especially when they do something that according to the law of the land is per se criminal? Like for example, having sexual intercourse with a child below the permitted age. How can an exception be sought with respect to that? How do you try to classify them in a separate category so as to get an exemption from the operation of the general noise limits?
The Lordship, this honorable court has self-recognized that tribes constitute a class, a separate class with diverse lifestyles, distinct cultures, and therefore they are a separate class.
Whether they could extend to criminal laws is the case. There's no doubt about it. They are a separate class, constitutional protections are there. They may be entitled to have their own legal practices, maybe have their own institutions. But when it comes to the general criminal law of the land, how do you say that there is a nexus between, if at all are challenging it under Article 14, is can there be a classification of us in this respect? And if at all there is a classification, is there a rational nexus between the classification and the objects of the age?
Your Lordship, the Council would like to first draw the attention of the court to Article 241, Schedule 5 and Schedule 6 of the Constitution, where it is stated that scheduled tribes can be governed by different sets of laws, Your Lordship, and in areas which are not declared as scheduled areas, there should be a different council should be enacted, and any offense committed in that area can be tried by that laws of the council.
Your Lordship, provision of the Constitution.
Pardon, Your Lordship.
If there is provision of the Constitution, it will enable the government itself application of certain laws in respect of scheduled areas or certain areas of state.
The Lordship, as per Schedule 5, in certain areas, the government can repeal or amend application of certain laws.
Is it amendment to be having exemption?
Pardon, Your Lordship.
Is it amendment of appeal or having exemption from application of the law?
The Lordship, indeed, it can be accepted from the application of certain provisions to those areas, and in areas such as and certain categorically in application to the scheduled tribes, Your Lordship.
Which is the provision?
Your Lordship, Schedule 5 and Schedule 6 of the Constitution as per Article 244, Your Lordship. That's obliged, Your Lordship. Your Lordship, moreover, the council would like to draw the attention of the court to the contention that no offence here has been committed by the accused, Your Lordship. He has been charged with penetrative assault. As per the interpretation of the word penetration under POCSO, it must be a routine action and positive act from the side of the accused. But here, it is a consented, mutually consented relationship. There is no element of exploitation or coercion, Your Lordship.
Then you can tell before they consent the judicial court. Why do you come directly to the Supreme Court?
Your Lordship, we have challenged this position before lower courts and high courts, and which has been bail to the accused in the present matter has been denied by lower courts.
So then you can tell the bail, the order fixing the bail.
Your Lordship, as this is a matter of public importance and affecting the community at large, and there is not substantial question and grave miscarriage, we are collectively challenging the constitutional validity of POCSO motions, the denial of bail, and so, Your Lordship, the preliminary assessment report and social investigation
Then you can confessing your arguments to the challenge against the motion as a law.
the council
Is
immediate option. The council is just putting humbly before the court that no offence has been committed by the accused. Your Lordship, now moving next to the
argument is based on customary care.
immediate option.
And the is a customer. Only private company. What is the effect of it is that it be arbitrary and of the law. So that way, they can really benefit from them. Can a custom using practice program as a part of the law from the proceeding constitutional revenue?
Your Lordship, personal laws and customs as per Article 13 are considered to be laws. As since the transfer of money judgment has been partially overturned in Shabalbala. Therefore, they should be considered as laws. This customary practice has been followed in the community, and moreover, the fact that a scheduled tribal, Your Lordship. So, this is what they have been following since ages, and that should be given importance. So, they accused here, and moreover, the victim. So, this is a natural act that takes place in their community, and they're really different from the urban modern society and their practice related to marriage and procreation, Your Lordship. Therefore, the uniform application of these provisions violates Article 14 of the Constitution, Your Lordship, and there is an arbitrary, Your Lordship. As per Shara Banu versus Supreme of India, India 2017 SC 4609, the court held that laws that are arbitrary and oppressive violate Article 14 and in Bombay Dyeing and Manufacturing Company Limited versus Bombay Environmental Action Group 2016 by SC 61. This court held that arbitrariness in the legislation violates Article 14 of the Constitution, Your Lordship, and therefore these provisions should be struck down. If Your Lordships make further a few more minutes, the Council will reconvene the next contention and issues. Much obliged, Your Lordship. Your Lordship, the last contention with regard to this issue is there is a violation of Article 21, the right to privacy and bodily autonomy guaranteed to the accused and victim, Your Lordship. In the case of J.A.'s Kuppaswamy versus Liquid of Surya, comparative case number 15, 2017 and STC, the court held that privacy is intrinsic to the right of life and personal liberty, Your Lordship, and explore the preservation of personal intimacies, Your Lordship. Moreover, it has been recognized in the case of Govt versus State of Madhya Pradesh, AR 1975 SC 1378, that these personal intimacies include marriage, procreation, and family life. And therefore, Your Lordship, the state is interfering in the right to privacy. Finally, Your Lordship, you ought to be satisfied with the argument that the provisions are indeed constitutionally invalid. The second issue that the petitioner is dealing with is whether Dr. Shukla has local standing in the instant matter. Your Lordship, Dr. Shukla has no local standing in the instant matter, firstly, because the right to reproductive autonomy is a fundamental right under Article 21 of the Constitution of India, and she has opposed his honor to violate the right to reproductive autonomy guaranteed to the victim here, Your Lordship. And secondly, Dr. Shukla here is a third party. She is a medicine law, a mere busybody. She has no right to approach this court and file a petition to terminate the pregnancy of the accused and by the victim and violate the fundamental rights. You also have a third
Why
contention.
would it be a public interest litigation where she does not confine in this particular case at hand? She is trying to bring out the notice of the court a larger issue that is affecting the tribals generally. So why not she maintain such a public interest litigation as when it comes to aspects that would affect the community?
Third option, the petitioner is contending that Dr. Shubhara is a valid by the intention. This should be considered as a publicity interest litigation, as observed by the court in Jananagar versus Texas Towery, AR 1993 FC came to. As third parties and one, she is a third party. She is filing this petition under the guise of public interest election. And moreover, she is also contending that the cases should be transferred to the court of
Is there a public interest element involved?
party lordship.
Is there a public interest element involved in this? Something that not confined to the parties here, but would affect the public accounts.
The lordship, but she is contending on two other grounds that are specific to the case they have. The termination of pregnancy of family, and secondly, to transfer all the cases to the High Court.
Just as instance, party is being pointed up just as an example, and she would ask for a larger relief, and the court will be able to lay down the law as it would apply to all in the future. That is all. That's the limited intention that he has.
The council likes to do for your lordship.
You may have to produce some material so as to raise it up some grounds so as to substantiate.
Your lordship, the council is
Clearly, I think that this is a public interest litigation, and throwing out every litigation of such nature would not be in the interest of justice.
indeed the lordship. The council is again contending that she has also asked for the transfer of all cases relating to this matter to the Court of High Court. And that itself relates to this particular matter, your lordship. And pertaining to this contention of Dr. Shubhala, she has no interest in the matter, and as per section 4.6 of CRPC, for a case to be transferred to a high court, the case should be filed by a party interested, and moreover, there should be some sort of reasonable apprehension in the mind of the victim here that the trial would not take place in a fair manner. So, by filing this petition, as observed in R. Balakrishna Pillai versus States of Kerala, 2007 SCG 129, she is stating that the transfer of criminal trial from one case to another is a display that Dr. Shubhala is contending that the state judiciary as well as the prosecution agency will not conduct a fair trial, and there will be injustice reasonable apprehension. Dr. Shubhala is a social activist. She is neither a party to the proceedings, nor she has any direct legal standing in the case of adoption. And therefore, even the High Court of Ernakulam itself has recognized that they have no jurisdiction in the instant matter of adoption. And therefore, your lordship, Dr. Shubhala, here is mainly contending based on some imaginary allegations and contours, and based on some conjectures and summarized definition. If your lordships are satisfied with the second issue that Dr. Shubhala has no local standing in instant matter, the council would like to seek permission to take these and call upon my council to deal with the next issue. Much obliged, your lordship. It was a pleasure. The council seeks permission to approach the next one. The lordships may go to the council would like to take the question. Your lordships, the third issue is whether the process of seeking a social investigation report and preliminary assessment report under the Juvenile Justice Act 2015, which begins the rights of elections to the process. The council submits for the honorable bench that the process of seeking a social investigation report and preliminary assessment report under the Juvenile Justice Act of 2015, which begins the rights of elections to the process on two grounds. First, that the preliminary assessment report consent is invalid. Second, that the accused rights against self-incrimination have been violated. Third, the accused right to privacy is being violated, and fourth, the accused right to fair trial is being violated. Your Lordships, according to Section 15 and 4 Clause 1 of the Juvenile Justice Act of 1980, the preliminary assessment report is to be submitted by the Juvenile Justice Court, which will contain a metropolitan magistrate or a judicial first-class magistrate with experience for at least 3 years, and 2 social workers, of whom at least one shall be with 7 years of experience in the areas of health, education, or welfare activities pertaining to children. In the MOOT proposition under paragraph 9, it is clearly stated that the state of Tamil Nadu sought the preliminary assessment report from a professor from a private university. Therefore, the council put forward this action of the state itself is a blatant violation of the law. Further, your Lordships, as per Section 15, Clause 1 of the JPA Act, and as per Rule 10A, Clause 2 of the Juvenile Justice Care and Protection of Children Model Rules 2016, the board will take assistance of psychologists, psychosocial workers, or other experts with experience working with children in difficult circumstances. This court, in Govt Thakur versus Gold, covered in 2312 SCC 401, your Lordships may kindly refer to case number 40, in page number 151 of the complaint. Court held that looking into the purpose of the 2015 Act and its legislative input, particularly to ensure the protection of best interest of the child, the expression made to provide so 15 Clause 1 deal with the requirement of assistance of experienced psychologists or psychosocial workers or other experts who operate as mandate unless the board itself comprises at least one member who is practicing professional the degree as child psychology or child psychology. Your counsel would also like to warn the attention of the court to three major consequences of the order of the juvenile justice system. First, the sentence or punishments can go up to life imprisonment. The child is filed as an adult by the children's court. Whereas if the juvenile is filed as a child, then the maximum sentence awarded is limited to 3 years. The second major consequence of the order you adoption is that under Section 24 Clause 1 and as per the 14 of the modern rules, the child will not suffer any disqualification attached to the conviction, but if this child is an adult by the children's court, such an option is not available. Further adoption, third major consequence.
If you pause there for a moment.
Mm-hmm.
How do you understand the concept of self-incrimination as political in Article 20? And how do you bring in that concept when it comes to the process of social investigation? Let me give you an instance here. In matters where a death sentence has been imposed, before it is being confirmed by the High Court, there is a process whereby the social circumstance, the economic status of the person will be taken. That is for the purpose of deciding on the sentencing part. It is not used with respect to the conviction part. Conviction would be based on the evidence and the law. When it comes to sentencing, it becomes necessary to understand the social background of this. So it is such an objective that such types of reports are being called in just for the purpose of assessing the sentence that will be in the document. Why do you say that it strikes against self-incrimination?
Your options, the council would like to first put forward the governing Section 15 of the Juvenile Justice Act, according to which a preliminary assessment report assesses the mental and physical capacity of the child to commit an offense, the circumstances under which the child is committing an offense, and his ability to understand the consequences of it. The second point that the council would like to put forward is that the consequence of this assessment is that the child is tried as an adult by the children's court, whereby his punishment or to life imprisonment. Now,
that exactly is the reason. When the sentence that would be imposed would vary from life imprisonment to maybe an imprisonment for 1 year or maybe less than that. How should the court assess this sentence or fix the sentence? Other than by looking at the social, the economic and the cultural background of the person, by calling for a report.
but your options, Here, the right against self-determination of the accused is clearly being violated. Because, as the council already stated, the punishment will go up to 9 years. And there are two other major consequences. And the child is supposed to be part of this procedure. There are some guidelines which came out in 2023 regarding this. But it was after the proceedings regarding this particular case. So there is no counsel present with the child who can actually prevent the child from answering questions which might be self-incriminating. And the counsel would also have to put forward the fact that here arbitrary relied on failures. All the courts in this particular
We must accept these issues together. We will come to the arbitrary delay of very data. First, we will have to clarify the position with respect to the first aspect. Are you saying that when it comes to the regulatory part of collecting this information, as you said, there could be some questions that we put to the child, it could be of self-incriminatory nature. So there is somebody who could be supervising. That is something that relates to the regulation of that aspect. For example, narco analysis test is how we understand self-incrimination. Collection of blood samples, collection of his hair. These are all things that we generally understand as self-incrimination. Comparing a person in evidence against himself. Here there are reports regarding the background of the person from the community in which he lives. Remain self-incrimination is the question. Are you regulation is part of requiring? That's a totally different aspect. That which would come into the purview of the school.
The council can already answer the question to adoption and to move forward the judgments. In the case of Rajwa Narayana Vansiliya versus Mani, Approved Mystery 1961 1 SCR 1 said, under paragraph 4 and 30, it has been stated that in the case where corporate acquisition has been made against the party pleading the challenge and it relates to the township offense, which is a long-term cost and result in prosecution, then Article 20 clause 3 is over. Further adoptions, in the case of Nandini Sarvati versus B.L. Rani, 1978, 2 SEC 4, the court laid down that the expression to be a witness against himself means more than the court process. Any type of implication or polishing of evidence is likely to have an incriminating impact. Answers the description of being witness against oneself, not being limited to the context stage by express words in Article 20 clause. The expression should be construed to apply to every stage when polishing of information and correction of convenience statements. The Lordship is satisfied the council would like to move on to the next convention. The next contention that is put forward by the council is that the accused right to privacy is being The Lordship, as per Rule 2.17 of the July Justice Care and Protection of Children Model Rules 26, the social investigation report contains detailed information pertaining to the circumstances of the child, situation of the child, of economic, social, psychosocial, and other relevant factors. Form 6 of the July Justice Care and Protection of Children Model Rules 26 contains a detailed performer of a social investigation. Under this performer, 3 parts are involved. An probation officer is supposed to collect information regarding the child's close relatives in the family, delinquency records in the family, social and economic status, ethical code of the family, attitude towards religion, relationship among family members, the relationship with parents, living conditions, etc. Under the second part, the probation officer is supposed to conduct investigation regarding the child's history, regarding his mental conditioning, physical conditioning, habits, interests, personality traits, neighborhood report, school, employment, if any friends, whether the child is being subjected to any form of abuse, and the circumstances and of apprehension of the child. Finally, the third, which is the most important part, the probation officer is required to inform the court about the emotional factors, physical condition, intelligence, social and economic factors, suggested cause for problems, analysis of the case, including reasons or factors contributing to the offense, opinion of experts, result of recommendation regarding the rehabilitation by a probation officer or child welfare officer. Thus, a detailed information about various aspects of children's rights stated in the Constitution and when child is an alternative adoption These pieces of information are preserved, thus blatantly violating the right to privacy in the life. The fact that detailed information is taken just to decide as to whether bail should be granted to the accused holds ground. Your Lordships, in the case of Francis Qurani Multipress, the administrator, Union Territory in Delhi and others, AIA 1981, SC 76, the Supreme Court of India referred to the views of the judges of the Supreme Court of West to conclude that.
If these reports are not taken, what would be the materials before the court in awarding sentence to you? There may be several positive factors in favor of bail in the courts. Then it will be detrimental to you if there is no.
Your Lordships, first of all, the council would like to before the honorable bench that council's contention are specific regarding the facts. And secondly, the council would like to raise the important point as to prejudice has been caused in this particular case. Because after the submission of the preliminary assessment report and the social investigation report, and after an article by Dr. Shukala was published in the newspapers, all the locals repeatedly denied bail to Muna, as well as the High Court dismissed petition, because of which the petitioners approached this already Supreme Court under Article 136 of the Constitution.
What are the factors to be taken into consideration when a bail application is put before you?
Your Lordships, as per Juvenile Justice Act, Section 12, generally, bail can be granted if there is a chance, bail cannot be granted if there is a chance the accused escaping from the illegal lodging.
That is what.
Within the limited knowledge of the council.
Are there any conditions laid down with respect to granting of bail? What are the considerations that you weigh with the court? Would the gravity of the offense be an aspect that should be taken?
According to Juvenile Justice Act under Section 12, Your Lordship, the gravity of the offense
The social conditions of it should be
in the approving as per Section 12, only the gravity
when it comes to, as you rightly said, when it comes to the question as to whether this man wants free away from justice, would it be necessary to understand the social circumstance?
Your Lordship, in this particular case,
Why is the passport being imported when bail is being granted?
Your Lordship,
Would a tribal have a passport?
Your Lordship, the council would like to confine the arguments with regard to the facts of the case, and as per Section
When you are dealing with the facts of the case and you are conducting on a legal proposition, these are the basis on which you should be conducting.
Indeed, Your Lordship,
Which is the judgment of the Supreme Court, which would lay down the considerations that the court should bear in mind while entertaining a bail. Because you are not free. Here the only question is the bail that is being sought is by the juvenile.
Your Lordship, council is unaware, council humbly apologizes for the difference. The council is unaware of the exact judgment as to where people laid down the conditions as to when bail is to be granted. But coming back to the Juvenile Justice Act under Section 20, it is clearly stated that the gravity of the offense, the seriousness of the offense, or the presence of surety should not be taken into consideration by granting bail to the offense. As well as Section 3 exceptions as to not grant bail is provided. First,
Do you know the exact grounds on which the bail of ineligible cases?
Lordship, in the facts, there is no such statement as to why bail is denied to the accused. But it is clearly stated that after the submission of the reports, as well as the and paragraph 10 is clearly specified that after the newspaper article was written by Dr. Shukala, all of the courts denied bail to the accused.
When you cannot check the legality of the order being bail.
Your Lordship, the order is not available in the facts of the case. Your Lordship, coming back to the three exceptions laid down under Section 12 as to denial of bail. So the first exception is that the juvenile is likely to bring him or her into association of any motive or expose him to moral, physical, or psychological danger, or that is treaties would impede the ends of justice. None of these conditions is present in the bill with these elections. Further, these reasonable grounds should be based upon the material evidence awaiting from record. It is not a matter of subjective satisfaction, but while declining to pay on to the jury or the said ground, there must be objective assessment of the reasonable grounds. This was held by the Supreme Court in the case of Manmohan Singh was held by the Punjab and Haryana High Court in the case of Manmohan Singh versus State of Punjab, PLR 2004, 156 PNH 497 vouchers. And further, the case of X versus State of Punjab 2024 SEC online department 179 was held that even if a child in conflict with law is transferred to trial under as an adult under 18 clause, his bail application shall be entertained under sections 20. Two options are satisfied in this particular issue.
You mean by entertaining a bail application? How do you understand that?
The council
Handling or considering?
taking the bail application in consideration.
That has been considered here.
But it was
And it was denied. He doesn't say that bail has to be granted, just entertaining.
Your options bail has to be granted is what position of section 12 is. Unless the three exceptions are present, and none of these exceptions are present in this particular case. Your option.
What more is necessary than of underage was pregnant and the pregnancy is terminated. You will this person, and that's what the law of the land. He's an accused.
Your option.
He's a juvenile. He will be taken as a juvenile.
Your option here, the accused is 15 years of age. Sorry, the victim is 15 years of age and the accused is 17 years of age. They have entered into a consensual marriage relationship under the practice of
Are they capable of entering into a consensual relationship?
as per the customary law of the indeed, Your Lordship.
Which law would remain? Customary law or the general law of the land? And if it is a customary law, why?
Your Lordship, in this particular case, the council would like to put forward that the customary laws must prevail. Because as per the rule regarding to the family custom laid down by Sir John Sandwich, as per the way Sir John Sandwich rules in page 209 stated that the true rule is that for the custom to be deprived of legal activities, it must so obviously and seriously requirement for rights and trees, such that to enforce it as law would do more mischief than this would result from overturning of the expectations and arrangements based on its presumed convenience and legality.
That's why we senior brother was pointing out. When would a custom become law? Or which is the provision in the constitution which would be relevant to discuss what is the definition of law?
The Lordship Article 30 should be taken into consideration as to whether a custom is law. And as per Maximum Pamali judgment, state in 1950s, the state of Bombay High Court has held that it cannot be classified as law, but the 2015-2019 judgment of the Honorable Supreme Court has held that custom is law under Article 30. So the judgment is partially known. And the Lordship, as per the definition of what custom is, it is laid down in, it is stated in the law executed by P. Ramanath High. He says that custom is a law not written, established by law, usage, and consent of our ancestors. No law can oblige free people without their consent. So whenever they consent and use a certain rule or method as a law, such rule gives it the power to a law, and if it is universal, then it's common law. If particular to this place or that place, then it is custom. In this particular case, it is custom, Your Lordship, to marry under the Swayamvara practice. If the Lordships are satisfied, indeed, Your Lordship. We also would just like to put forward a last contention, which is that with regard to the second issue, Your Lordships, the conditions that drive early marriage should be personally addressed. In society, for enlightenment, which was 2024 IAC 790, the court enshrined that the needs of protection before prevention should be given importance. Further, in the case of Vishraka versus State of Rajasthan, 1997, 6 SEC 241 laid out that gender inequality in harmful practices cannot be eradicated solely by statutes and mandates. Further, in the case of a State of Rajasthan versus Shanghai, 1996, 4 SEC 150, the Supreme Court recognized that success of any legislation depends upon its ability to align with values and needs of community. Your options are signed.
So, what is the importance of criminal law when it comes to prohibiting a social practice which we perform as so abhorrent? Do you mean to say that prohibition by law need to wait social enlightenment? If that is so, let us take the instance of study. Do you think that study is not being practiced here because we have been penalized, or because then their country has become so enlightened that we have all the rights?
Your options, first of all, as far as your contention as to your options contention as to study and
Just make a solution.
and your as far as study is concerned, the council agrees that because first the law came to place and
Study was created. 10,000 people took out a procession in London against that law.
indeed your options. But here a different position can be solved by this solved by this particular
Practice, custom, either morality, all was there when it came to study.
Indeed, the council agrees with your point, Direction. But here a different position can be taken by this honorable report, because first of all, the tribes constitute a separate class. Their protection, their rights to protect its culture is protected under Article 29 clause 1 of the Constitution.
What if they have this practice of study now? The rights.
Election to council is against the practice of study. It must be
We
abolished.
saw the question is, how would we prohibit it? What is the method of doing it? Why do you say that a law that prohibits a socially abhorrent practice should wait for social enlightenment first, then only law enforcement? That was in contention. That is why you think so.
Election to council's contention is that first the problems as to lack of economic empowerment, lack of access to education, healthcare, all these things should be taken into consideration. And as per Section 43 of the POCSO Act, the legislature has a duty in order to publicize the provisions of POCSO in the private communities also. This is not being done in this particular case of council. So, and the council would also like to put forward the fact that if this court now is giving an order which violates the custom of this particular tribe, your lordship, more harm would be done to the petitioner, because all of them are juveniles and the mother and she's already pregnant, huge mental distress is caused to her because her husband is in jail. And further, the fact that Munna accused is the sole breadwinner of the family, and that their whole economic background, all these must be taken into consideration, your lordship. Much obliged. The bench is satisfied with the arguments the council seeks version go on to the light of the issues raised, arguments advanced, and authority cited. This most humbly prayed before this honorable report that we may be pleased to grant and declare that the Law and the Protection of Children Protection Offences Act, which treats the sexual act of married couples as violative of the law, is unconstitutional. Secondly, Dr. Shukla has no notice standard in this matter. Third, that the social investigation report and preliminary assessment under the Juvenile Justice Act of 2000 is invalid and vitiates the rights of the accused in a criminal cases. And fourth, that the restricted articles Swaimara in the community should be protected. And the order passed implement order on election, which would be to be respected in the end of equity, justice, expediency, and good conscience, with even the petitioner. And for this act of kindness, the petitioner as to be found should forever remain attached. It was a pleasure having you here. Council seats in addition to the guide. Greetings to the bench. The council seeks permission to address the bench collectively as your lordship. Much obliged, your lordship. Your lordship, this is the council on behalf of the respondents in the present matter of above and SRP versus Union of Irony and was a procedure established by the Juvenile Justice Act, and hence no question of no substantial question of law arises in the question.
Sir, they are selling the constitution directly crucial. And they can legal approach.
Part of the question.
They are selling the constitution directly also and so their fundamental rights are affected. So they can guarantee on Article 183.
However,
Category of substantial question of law that a challenge for the constitutional validity of our statute. When the constitutional validity of the statute is being challenged, as a prime question, which would be necessary to be required under ordinary physics. Why do you say, and what do you understand by the substantial question? Which are the leading decisions of the Supreme Court where the Supreme Court had started off what constitutes a substantial question?
Your Lordship, in the present matter, the procedure followed by Juvenile Justice Board was that is established in the Juvenile Justice Act.
You cannot be able to answer by referring to the facts of the case. The question is more legal in nature. How do you understand the substantial question? And what are the parameters that are being laid out for this board to assess whether a question that is important is a question of law or what? And secondly, whether it has a substantial.
Indeed, Your Lordship. Your Lordship, in the case of Abdasan versus Union of India, it was stated that especially petition is a matter of discretion and not of right. Hence, in the present matter, the court, the council believes that the, Your Lordship, there has been no gross injustice on part of the, part of the state, as there has been no gross irregularity or violation of any laws provided in the constitution provided. Serious offending, the serious crime of rape and hereditary sexual assault has been committed by the boy, the present man. However, Your Lordship, an ordinary remedy under Article 139A, subclause 2, is sought by Dr. Shukara in the present matter. If Your Lordship speak for the assistance of the bench, the council please Your Lordship to please turn on paragraph 10 of the MOOT proposition. Towards the end, it's mentioned that Dr. Shukala is requested to Apex Court transfer of all the cases relating to this incident to the High Court of Kolkata to court jurisdiction of the High Court of Kolkata. This acts as an alternate remedy as the Lordship Gandhi, who is a 15-year-old minor, is under medical distress and is from the state of Kolkata. The state of Kolkata has jurisdiction to hear this matter, and this article this article of 139A clause 2 acts as an audit remedy that should be upheld. Hence, Article 136 not be made.
Counsel, what is the organ convene when the constitutionality of the statute is challenged?
Your Lordship, the alternate remedy here, as paragraph number 8 of the MOOT proposition states that Dr. Shukala went to the High Court of Kolkata asking for the termination of pregnancy of Gandhi, which was dismissed on grounds of jurisdiction. The matter was not heard on grounds of merit. Hence, this matter, then she went to the Supreme Court asking for 3 grounds. First, she's asking for the termination of pregnancy of Gandhi. Second, she has asked for a standardized marriage age in all the primary communities. And third, she has sought transfer of all the cases related to this incident to the High Court of Kumbh and to the High Court of Kolkata. Because Gandhi, who is the victim here, who is a 15-year-old minor, is facing medical distress as mentioned in paragraph 8 of the MOOT proposition because of the kind of as the report of the medical team suggests. Hence, the alternate remedy and there is an alternate remedy for which the article of these things, especially for me, should not be implemented. If your Lordships are satisfied with the first issue you have had, the council would like to move on to the second issue. That is, whether the sexual act committed by the minors is valid under the first category. The scheme is also explained in a way of 2 productive. First, that the child marriage is invalid, and second, that the sexual act committed by the minors is also invalid. Your Lordship, moving on to the first thing of the arguments. It is a very well established notion, Your Lordship, that child marriage is a social evil. The state has been let down in the judgment of society for enlightenment and voluntary action versus hearing of anger. For the assistance of the bench, the council would like to bring Your Lordship. Turn over to page number 17, paragraph number 10 of the written submission. It states that in the case of Abdul Hadar versus KPG of the child marriage prohibition system, it was held by the court that the practice of child marriage directly contradicts the provisions of the Prohibition of Child Marriage Act of 2006. Your Lordship, for the convenience of the bench, the council will also be Your Lordship. Please turn on page number 57 of the complaint. Your Lordship, it is rightly mentioned in the case of Abdul Hadar that the intention of the Prohibition of Child Marriage Act is to restrain is to protect the children from child marriage. The main intention of the provision of the statute is to abolish the practice of child marriage, which is a social evil. Your Lordship, it is also to be noted that customary practices cannot override the provisions of the statutes. It is mentioned in the case of, as it is mentioned in the case of Raja Reddy versus State, that personal laws cannot prevail over statutory provisions. customs which are inconsistent.
to the formation of the Indian Constitution governing the force. Are tribals and tribal areas entitled to any special status?
Your Honor, the tribal areas are entitled to special status under this Schedule 5 of the IGP Constitution. However,
The Constitution envisages that any law made by the Parliament can be exempted from application in certain private areas by the government of the state. What do you think is the relevance of conducting that child marriages are illegal? Then it is a general law. But when it comes to certain areas which are going to provide the operation of general law has been exempted, it doesn't matter as to what we perceive of it or what generally the law policies are. They are entitled to their own exemptions based on their customs and practices. So what's the point in conducting that child marriages are illegal, aberrant? Doesn't matter because as far as the practices and customs are concerned, this is something that has been going on, and the Constitution permits it.
Your Honor, as it was mentioned in the case,
Which is the provision of the Constitution that envisages specially guaranteed protection or extension to private areas.
Your Honor, Schedule 5 mentioned this is some of the Constitution of Ireland states that. However, Your Honor, the Council like your attention to the fact that any custody that inconsistent with the laws of the country cannot be appealed.
In that, there is no such provision because it says any law made by the Parliament can be exempted. So such a categorization that as provided an exemption doesn't matter because any law, even the IPs, even the CRPs, will be exempted from being applied in private areas if the government fees.
Indeed, Your Honor. However, any sort of practice of child marriage, which is such a social evil, that it's
Not in the private area, it is not.
however, Your Honor, such practice is against the legislative provisions of the country, and also that this practice violates the fundamental rights of the girl child. Your Lordship, under the by the annual of judgment also was mentioned that any laws inconsistent with any customs inconsistent with the laws of the country cannot be applied for custody.
What is the important schedules that you mentioned? Why do we have no schedules there?
Your Lordship, the Constitution of IBD understands that the scheduled rights have to be protected under the Constitution of IBD as we have mentioned.
What do you mean by protecting the scheduled rights? Protecting their lives or protecting their husbands and rights?
The provisions are under the Constitution. Because the law to the people are aware of the fact that as the rights are considered, the extended rights to living before the law. Second, people belong to the private community cannot be aware of the laws of the land. So there are no mechanism for the law practicing law. That is especially why is the provision for exempted mandate for the government to exempt the law from its application in private scheduled area or any area perspective. So if the beginning insertion is that the constitution will take the country. How can you say that the representative practice the delegation of the provisions will be go outside so that the party will be there also be made as a initiative.
Indeed, Your Lordship. Your Lordship, I think that's the case. Paragraph 6, it states that the social welfare department warned the family for the legal consequences according to the IB's criminal laws. Hence, in this matter, the family, the parties, for the legal consequences. And Your Lordship,
Was pregnant.
Your Lordship,
So I wish that the girl is pregnant.
indeed, Your Lordship.
What's the point in what to make on the existence of the law? How could that has already been done?
Your Lordship, in present matter, the Lordship,
Do you think that the tribals who leaving the far the purpose in the country knows about the box right? Everyone else is like they don't know.
However, after the information about the legal consequences also, the family and auntie refused vehemently opposed the Russian facts of the case. Do not say that the government detectives. This scheme has been solved at official the pregnancy of Kandi should be terminated. The pregnancy has not been terminated as per the facts of the case. However, for a girl 15 years of age to be married this early and to get pregnant at such an early age has was developed a health effects to her, as is mentioned in the facts of the case itself, Your Lordship. And also, Your Lordship, the state that they just limited case law, the paragraph number 20, page number 21 of the written submissions of the respondents is given. It is given in the case of Malguma versus State of Kerala, and the court held that courts for India here only when the standing clearly violates the rights of citizens provided under Part 3 in the Constitution, or when the act is beyond the legislative competence. In the present matter, Your Lordship, the charge of rape has been put as the charge of the offense of rape. Section 375, exception 2 of Section 375 of the IVD Penal Code is struck down by the independent court versus Union of India judgment. This left judgment has mentioned that such classification of a girl child birth rights gets discontinued unfit because the girl is of 15 weeks. Only because if a girl is married and is between the age of 15 to 18 cannot be classified as an adult or cannot be and her consent cannot be treated as the valid consent. Even though the facts of the marriage was given that she gave a valid consent that she was married, but the marriage together is not valid in the present scenario of Your Lordship. As given in paragraph number 5 of the session, it was a customary practice, not a customary law. And also, the consent of the girl child cannot be obtained as the provision of POXO states that for a consent to be valid, the party should be of 18 years of age. It is a well-established notion that for consent to be valid, a person should be of majority age. And here, Munda being 17-year-old minor, 17-year-old boy, and Kangiri a 15-year-old girl cannot in any sense have given consent to the marriage or to the pregnancy altogether. Such pregnancy or lordship at such an early age, it was detrimental health risks which is caused in the present matter, and for the welfare of the child, the best interest of the child. Dr. Shindler is seeking the termination of pregnancy of the girl. But the lordship of access is commercial. Your lordship, it is established that that exception 2 of the section 375 of the IDD Penal Code is discriminatory in nature, as we should not discriminate a girl child from a child who is married. Hence, in the present matter, Gandhi and Murna did not give consent to the marriage, did not give consent to the marriage or to the pregnant or to the consent to the sexual act which was committed. Hence, in the present matter, the sexual act committed by the parties should not be used. If your lordships are satisfied with the act is presented by the council, the co-council would now proceed with the name. Much obliged. The council seeks verification of so, right, your lordship. Your lordship, this is council under for appearing on behalf of respondents. The council will be dealing with two issues at time, issue number 3 and 4. Issue 3 pertains to whether the procedure for seeking credible assessment report is in accordance with law or not, and the denial of bail for is violative of his fundamental rights. Your lordship, the council seeks permission to proceed with the arguments at hand. Your lordship, this issue would be dealt in a twofold manner. First, the procedure followed is in accordance with Juvenile Justice Act. Second, the denial of bail to Munna is not violative of his fundamental rights. Your lordship, in the present scenario, Munna, as given in the facts of the case, was charged with rape and penetrative sexual assault, which falls under the category of heinous offences, because the punishment for rape and penetrative sexual assault exceeds the minimum punishment of 7 years. Your lordship, for the assistance of the bench, the council needs your lordship to turn on to para 9 of the MOOT. Your lordship, the procedure adopted in the present paragraph is in accordance with section 15 of Juvenile Justice Act, which which makes it mandatory for the Juvenile Justice Act to conduct preliminary assessment report and social investigation reports for a child falling under the category of 16 to 18 and who has committed heinous offense. Your Lordship, as rightly pointed out by my opponents, that this procedure or this thing was adopted in the Constitution. This thing was adopted in the Juvenile Justice Act because the aim of the Juvenile Justice Act was to protect the innocent minors, not those who are hiding behind the veil of minority. Your Lordship, various reports, NCPCR reports, and lot of reports mentions that 76.4 juveniles who are to be accused fall within the bracket of 16 to 18 years. Thus, Your Lordship, to create such a provision of Section 15 was well in compliance with principles of proportionality, that severity of crime should be in accordance with severity of punishment.
Punishment is more than 7 years. So cannot grant bail.
It means an option. The
If so, under the paragraph, it's to be microphone. I propose that.
Your Lordship,
Not to do the
or your Lordship, I repeat,
said that funds. I think it's more than 7 years. The work of that today.
nothing is there mentioned in the bracket.
What don't get saying that the check cannot be mandated. Other than non-committee.
Your Lordship, denial of bail in the present scenario is in accordance with Section 12 of the Juvenile Justice Act providing that mentions 3 grounds on which the bail would be denied. And the present scenario, the last ground has mentioned that a bail could be denied if it defeats the ends of justice. Your Lordship, the very intent of Juvenile Justice Act is to have a reformative and rehabilitative approach.
Dealing with the case of a private
Need.
marriage, according to his customs prevailing there. He is not aware of any of the laws that have been passed by the in the country. There was no access to those details. And that is so. You know, consider that and bring to the making. But capitalizing. The thinking in the case of a private. That is 17 in the form of like.
Your Lordship, first and foremost, we are representing the state. The state is not at all against. The state is not at all disrespecting their customary rights. Your Lordship, as reiterated time and again by my co-counsel, that child marriage is social evil.
Every day that is.
Your Lordship is responding to the arguments presented by the petitioners.
I'm asking you. These are serious objection that we have. Denied pain. The facts and certificates and case.
Your Lordship, Juvenile Justice Act is framed to reform and rehabilitate. Your Lordship, time and again reiterated by my co-counsel that it is a child marriage is social evil, and Your Lordship, ignorance of law in any which manner can never be pleaded.
I accept that. And that as a difficult case of other reason by that. See, the ignorance of law is not an excuse. I admit that. If that is so, that laws to be made other people. There will be a mechanism to make them aware of this law. When the sun is either little far away, and that is not being passed by the parliament inspector.
Your Lordship,
And that principle is strictly applied. That's a principle. That ignorance of law is not an excuse.
Your Lordship, there are lot of reports, even mentioned in our written submissions. The NFHS reports to point out that today child marriages are most prevalent in tribal communities, and they are creating deteriorating health effects. And Your Lordship, we as state work for welfare of the community at large. Your Lordship, is very fact that child marriage social legal can never be hidden.
2 aspects. In juvenile justice matters, he is playing the role or jail for
Your Lordship, it is in common parties and it is cycle again that bail is the rule and jail is the exception. But your Lordship denied
Mr. Sir. It is even more.
in
It is very section 12.
your Lordship, it specifically mentions the word shall. But your Lordship, the proviso do mentions the 3 grounds to deny the bail. Your Lordship, the last ground mentioned that if the bail given, it would defeat the ends of justice.
When the ends of justice be served after the fire.
Your
So he is not guilty as of now. Ends of justice will be served after evidence. It is proved that he is guilty of the crime. Then he will be visited in the punishment. Now he is only asking for bail. It's a trial has not started. Why should the trial, why should the bail be denied for guilty? Especially the section where it says that a juvenile shall be given a bail.
Your Lordship, the paragraph 9, clause 9, suggests that the board in the light of reports suggested that the trial of the accused is to be made before the children's court.
Correct.
Your Lordship, the reason for denying bail here would to serve the best interest of the child, not harming any of his cultural
Yes, that's right.
Munna.
Yes. So would his best interest be served by granting bail or sending him to jail?
Your
It's all
Lordship,
fine.
Your Lordship, we are dealing with Juvenile Justice Act. And your Juvenile Justice Act per se mentions that a child in any aspect be sent to jail. Your Lordship, the child would be sent to place of safety or the special police units. Then reformative approach would be adopted. Your Lordship, the present should happen
Before even finding him guilty.
Your Lordship, then in that circumstance,
We invariably send to a facility and we be great before it is proved as whether he is being guilty of some that cannot be done.
Your Lordship, before being tried or before being sent to a place of safety, the child should be sent to the special units, which is established.
Why don't we have bail?
Your Lordship, then the very purpose of reformation would be entirely struck down.
It's the information between this matter. Before the accident can happen.
Indeed. Your Lordship, as we look into the facts of the scenario, the factual matrix, it is well known that Munna was a person of societal influence. He was leading the plantation course of his entire community. He was time and again going through the social meetings. This altogether mentions that yes, he was a person of societal influence, and your Lordship, his very community is practicing a social evil, thus to reform the entire community and to work for the benefit of all the people around.
There is a sentence in the facts which would help you, which you have not counted. Says he had relationships with 2 other things. So if left on bail, he may have more termination of pregnancies. Could be one of the reasons that he would possibly conduct. Which you did not do. That is why we are getting cautiously or rather to help you and as separate saying that he has a relationships with other those.
So that's the only point with us on why we are denied to be. We are giving you the place of safety, you will be informing it all together. You will be making it aware about yes.
Would possibly justify it for this reason. That's what I want to do that.
Justify
Reason if specifically without the running in way because he's a person who is prone to such kinds of activities.
Your Lordship, keeping him in the place of custody won't justify any of this. The major reason for denying his bail is to have information altogether and to make him aware that what his community, that is following the customary practice. That is
My brother was saying something, saying that taking consideration is was combined. This electron wave is repeated again and again. So we should not be carried away.
Continue. Your Lordship, thus in all of his proves that his aim is being denied with the right of information and rehabilitation that belongs to the purpose of human justice. Your Lordship, moving on with the further arguments. Your Lordship, the procedure followed by Juvenile Justice Act was in compliance with Section 50. The Lordship, paragraph 9, good proposition line number 9, explicitly mentions that a person was appointed by the Juvenile Justice Board and he was the professor from private university. Your Lordship, Varun Chandra Thakur versus Master Goldman and others explicitly mentions that there need to be a psychologist, a social psychologist, a social worker, or an expert who have practice, who have experience of working with children. In your Lordship, a professor is very noble profession. Professors have experience of working with children. And your Lordship, Juvenile Justice Board itself appointed that professor for its assistance. Thus, your Lordship, this creates a safeguard for the entire report. And your Lordship, these reports are carried out to establish physical and mental capacity of the child and to analyze all the social backgrounds of the child. Your Lordship, in the present scenario, the factual matrix, all the findings of the reports explicitly mentions that Mutta was physically strong and an influential person. He used to conduct meetings. He was a leader himself. He can even perform the marriage with Gandhi without the consent of his parents. That to be the state of Balkara. The Lordship proves that he had the mental capacity to be analyzed as an adult.
That's why they spoke of the Swayamana system. Passenger parents are not necessary.
Your Lordship, if
And tribals, they don't believe in state borders. They just move on from one place to another. State borders doesn't prevent them. So whether she is in Kolkata or in any other state, for a tribal, it doesn't matter. And just as my brother was pointing out, even the fact that a boundary of a state bifurcation has been done is not told to them. They live in a kind of perfect natural state. Oblivious of the changes that the parliament has made, or even the existence of the parliament.
Your Lordship, the line of paragraph 9 explaining the custom of Swayambara states that teenagers can choose their life partners and decide on their marriage, and the family used to accept it, which means that they can decide on their marriage, but for performing that marriage, they need the consent of their parents. But your Lordship, in the present scenario, Munna, without the consent of his parents, mentioned Munna, without the consent of his parents, married Kanti altogether, which shows that he has the mental capacity to understand whatever he was doing. This altogether mentions that he could be categorized as an adult and he would be treated in the way an adult is to be treated. Lordships, if the Lordships are satisfied, the council seeks for going to proceed with the fourth issue at hand. Your Lordship, fourth issue pertains to whether the demands of Dr. Shukala are maintainable or not. Your Lordship, this could be dealt in a twofold manner. First, Kanti's pregnancy should be terminated. Second, the court can issue guidelines to protect the woman's health. Proceeding with the first limb of my arguments. Your Lordship, paragraph 8, MOOT proposition line number 2 mentions that Kanti was going through detrimental health conditions because of his pregnancy. Your Lordship, the council paid your Lordship to turn on to page number 27, paragraph 53 of the written submissions. Your Lordship, there is a report cited which states that it is noticed that female deaths during the pregnancy in the age group of 15 to 19 years is substantially high. Your Lordship, even Kanti was going through detrimental health conditions and the medical team to ask her to get her pregnancy terminated. Your Lordship, the very purpose by bringing in Medical Termination of Pregnancy Act is to do away with all such unwanted pregnancies and to keep mental and physical health of a woman at utmost priority. Your Lordship, this detrimental effect or this pregnancy should not be just seen from the angle of mother. It should be seen from the angle of fetus itself. Your Lordship, Gandhi was hurting a child, husband is living behind the bars. Your Lordship, she would be able to provide holistic development to the child to whom she would give birth to. Because Article 21 is not just about bringing the child in the world, it is about providing a holistic development to protect the, thus, Your Lordship, in the present scenario, to protect the interest of minor, to protect the interest of fetus itself, the pregnancy should be terminated.
How is the universal features provided for you making it?
Indeed. Your Lordship,
What stage does the regular termination of pregnancy act permit termination of pregnancy?
Your Lordship, it is
How many months?
20 weeks.
Yes.
Your Lordship, in the present scenario, it is indeed, I agree with that. But Your Lordship, we are dealing with a minor who is going to determine
So minor.
Kanti herself, the mother.
What about the status of fetus, which has almost reached a stage where it is attaching the its hands on you? Does the fetus have rights and opinion?
Your Lordship, in the case of ND versus Chandrama, it is stated that the court should strike a balance between the interest of the mother and the interest of the fetus. Your Lordship, the council is contending that the mother who is herself going through mental distress, the husband is not there, she may even
When was there? When was there?
but
Oh, might be. Or else they would have been happily living together in the past.
indeed, Your Lordship. Your Lordship, she was going through detrimental health conditions. Your Lordship, the very purpose of bringing in MTP was to keep the physical and the mental conditions of the mother at the most importance or of paramount importance. Your Lordship, in the present scenario, Gandhi was herself a child would be able to provide the fetus, the holistic development when the fetus would be born. Thus, Your Lordship, the termination of pregnancy is demanded in the present case and it should be it. Your Lordship, proceeding with the second thing of my arguments. Court can issue orders to protect the health of women. Your Lordship, Dr. Shukara demanded that court should issue order to enact a legislation to have a uniform marriage age for all the tribal people. Your Lordship, as reiterated even earlier, NHS report do mentions that tribals, that child marriages are quite prevalent among the tribals, and they are going through determined health conditions because of these child marriages. Your Lordship, this is because there is no uniform age or there is no act which makes it mandatory for the people to get married at the uniform age of marriage. Thus, Your Lordship,
It is already in our specification says that 21 is the age for male and 18 is the age for female. Why should there be a difference in the age limit prescribed about tribals? And the practices of the tribals that reserve a maybe for the tribals by having. So what is the kind of uniform law that you envisage for tribal marriages?
Your Lordship, the Dr. Shukara is demanding uniformity in the sense of Your Lordship, Dr. Shukara is demanding uniform marriage age in accordance with Special Marriage Act. Your Lordship, till now, Special Marriage Act is not applicable on tribals. And Your Lordship, Shukara is demanding the age and the age prescribed under the Act is 18 for girls and 21 for boys. Your Lordship, this is scientifically proven that this is the perfect age to get married, both medically, physically, and in all other aspects. Thus, Your Lordship, bringing in uniformity to align with the principles of Article 44 as inspired by our constitutional framers that there should be uniform civil code. Your Lordship, thus Your Lordship, this demand in order to ensure equality, uniformity in the system, and the other council team, Your Lordship.
The person you want to civil code is the model code. There's an exception to try this.
Your Lordship.
The person you want to civil code, they need to accept the entire findings for the habit of the rules.
Your Lordship, the state is here to bring in that demand that there should be a uniformity in order to condone or in order to do away with all such social evils. There's a need to bring in uniformity. It may take time, but there is a need to bring in uniformity in the system in order to ensure equality. Your Lordship, the council seeks permission to proceed with the prayers at hand. Whereof, in the light of issues raised, arguments on merit, evidence supplying, authorities cited, it is most humbly and respectfully prayed that this Honorable Supreme Court be pleased, finding, adjudged, and dismissed the special leave petition filed before the Honorable Supreme Court of Adelaide, declared that the marriage sexual act between the minor and between Munna and Kanti is invalid, that sexual routine of Juvenile Justice Act is constitutionally valid, denying of bail is reasonable and just, that the writ petition filed by Dr. Shukla is maintainable and in all pass any order of direction or relief, that this honorable court may be implemented in the interest of justice in the recent it is an honor article. Your Lordship, the first contention that the Govt Council for respondents raised that this petition is not reasonable. Your Lordship, this petition itself is reasonable as there is a substantial question in law involved. The constitutional liability of counsel and the preliminary assessment and social investigation report under JJR. And moreover, Your Lordship, there is a grave miscarriage of justice here as Munna has been denied bail repeatedly by the lower courts. And as the Govt Council for respondent contention, transfer of cases from one jurisdiction to another jurisdiction of High Court is not an alternative remedy in the present matter. And the Council would like to bring the attention of the court to the judgment of Chunila and Sons versus Centuries Spinning Wheels, where the court held that substantial question of law, which is a question of public importance, which directly affects the rights of parties, and which has to be settled finally by its honorable court. So the petitioner has approached his honorable court to settle a substantial question of law. Then, Your Lordship, the second contention here raised is that the petitions can be transferred from the court of Kumbanala to Govt. Your Lordship, this transfer petition not satisfy any prerequisite condition for transfer under Section 416. And more important, they have raised the contention that Dr. Shukla can file a petition for termination of pregnancy, Your Lordship. The council would like to take your notes into the case of Sujitra Srivastava and another person standing in administration. Area 2010 SC 235, where the court recognized that reproductive autonomy is fundamental rights granted under Article 21, and women's reproductive choice must be respected even in cases of mental incapacity or apprehensions about maternal responsibilities, Your Lordship. So what should be considered here is that Kanti herself is not willing to terminate a pregnancy, and her guardians have also expressed unwillingness. So in such a case, Dr. Shukla cannot approach his honorable court to violate the fundamental right guaranteed to Kanti under Article 20. Next, the council would like to bring the attention of the Govt Respondent Council to the fact that child marriages under Section 3 of the Prohibition of Child Marriage in 2006 is only voidable and not void, and is only voidable at the option of party contracting legal child. For an option, the council would like to draw the attention of the court to the fact that child should be treated as a separate class of option. The guaranteed equal protection law does not mean that, as the respondent council contended, same laws should be applicable identically to all. Your Lordship, here the tribunals in the modern society are not alike. They live in different social circumstances and they follow different customary practices. and therefore uniform applications of provisions would be violated in Russian. And moreover, Article 29 Clause 1 is given absolute terms and cannot be subjected to reasonable resolutions in the interest of general public, like the right enumerated under Article 19 Clause 1 escalated by the respondent council in Russian. And this was upheld by the Supreme Court in the case of US Srinagar Rao versus the Nation in Ananda, AR 1983 1896. Moreover, Your Lordship, the council would like to bring the attention of the court to the fact that the respondents have claimed that misinterpreted the facts of this present case. They have claimed that Uncle is indeed a private, the name of was in private plantations, Your Lordship. If you are asked kindly about the paragraph 5 of the MOOT proposition, it stated that Uncle was an active member of the private name of was in plantation, Your Lordship. And he was a sole breadwinner of the family. And that should be taken into consideration by Your Lordship. And moreover, Your Lordship,
The facts also saying that he was almost on the footsteps of his father who was a leader of people, and he's almost in the footsteps of his father. So why shouldn't we take him as a person who would be looked upon as a model by the entire community? And if this is the model that he gives, then why shouldn't he be denied bail and informed of what the general civilized practices of living are, as they call them? They have a specific convention. When bail is being denied, not being sent to jail, but to reform. Why can't we agree to such a course, especially if he is a person who would in future be leading the riots?
Your Lordship, the council would like to complete statement of sound report. Then currently, Uncle is the one who is languishing in jail, not his father. And we cannot judge a person based on the footsteps of his father. And secondly, Your Lordship, the council would like to place the prime importance of customary practices, Your Lordship. And as observed in the Constituent Assembly decrees, when amendments to Article 35 were proposed, Dr. Lordship, Mr. Mohammed Ismail Sahib raised that any group section of a community of people shall not be obliged to follow and adhere to personal laws as among the fundamental rights. And this provision should be really amongst the statutory and justified by fundamental rights, Your Lordship. The right to follow these customary practices is a part of the way of the life of these people. And if anything is done affecting this personal laws, which is amount to interference with the way of the life of these people, Your Lordship. And Your Lordship, moreover, as per the contentions of the respondent council, the council would like to draw the attention of the court to paragraph 9 of the court proposition, where it stated that states sought preliminary assessment report from a professor. And as per section 4 clause 1 and section 15 has stated that the report must be prepared by a board consisting of a first-class judicial magistrate with 3 years of experience and 4 social workers with 7 years of experience in the field of child rights, Your Lordship. And this has not been followed by the Your Lordship. And moreover, section 110 states that state rules cannot be under the state rules council force. Central order rules will prevail, Your Lordship. And it's to the facts of the case, the state rules hadn't come into force. So the central order rules that have prevalence here. For Your Lordship, with regard to the bill and the issue the Honorable Lordship posed, prejudice has been caused to the accused by the submission of the report, and with regard to that, the has been denied. As per section 12 of the Act, JJR, they cannot be denied on the basis of gravity of offense, but only if there is a chance that the accused associated with criminal or by criminal association or when it's exposed to psychological moral damages or any acts of justice are repeated, Your Lordship. And it's claimed by the respondent counsel, all these conditions are not satisfied here. And moreover, the Lordship is not printed contingent that the best interest of Buddha is saved by denying bail to him. But as for the fact, Buddha has not committed any offense, Your Lordship. And he got married as to the customary practices of Swayamvara. And it should be considered that as for the fact, Buddha is an uneducated person, Your Lordship. And the council again placing great importance on the fact that he is a sole breadwinner. He comes from a poor economic background, and his arrest himself has put his wife Army in mental and physical distress, Your Lordship. And moreover, Your Lordship,
You can find them.
there are this one more contention that the state does that by
No more fresh conventions again. Just submit, you can submit
The Lordship, the state itself has failed its duties and whereby is prosecuting the accused, Your Lordship. That this comes with the attention of the bench. I should like to know. The Lordship, the constancy explanation to proceed with the survey reports. I should like to know. Your Lordship, this very practice of child marriage again reactivated, is against the laws of the country. And Your Lordship, adopting the custom, it should align with the practices of the country. And Your Lordship, in the present case, child marriage nowhere aligns with the laws of the country. Further, Your Lordship, the opponent counsel pointed out that the preliminary assessment report and social investigation report sought to be made by Juvenile Justice Board. Your Lordship, in the present scenario, Juvenile Justice Board conducted the reports and Your Lordship is seek the assistance of the professor, which is a mandate after the judgment of Varun Chandra Thakur versus Master Mohan and others, as per section 15, clause 1 proviso. Your Lordship, it is rightly stated that tribals cannot be exempted from the criminal acts in any which manner. Your Lordship, the Kanti's pregnancy could be terminated by invoking the principle of parents patria. Yes, we agree with this, that Kanti was against this idea of termination, but Your Lordship, a minor can never give consent to the very act. Thus, Your Lordship, invoking the principle of parents patria, and the state is there to work for the welfare of the citizens. Kanti's pregnancy should be terminated. Further, Your Lordship, this very nature of the act of child marriage and various other acts of allowing pregnancy in such a marriage age, in such a younger age, is inherently deteriorating health conditions of the community. Thus, Your Lordship, this should not be allowed. Your Lordship, as Your Lordship also agreed with this on while I was arguing that yes, the bail should be denied and for the reformative approach for the best interest of the child, the monarch should be
Jail should be accepted.
no, bail should be denied and
Jail should be
Your Lordship,
for that.
Your Lordship, minor can never send bail as per section. A minor can never send jail as per section 10 of Juvenile Justice Act. Your Lordship, the minor should be sent to place of custody for informative. Further, Your Lordship, the intent of GGB is to protect the best interest of the child. Whatever GGB did in the present scenario was all together in the best interest of the child and it should be served. Further, Your Lordship, the petitioners are itself challenging POCSO Act. Your Lordship, POCSO Act include minors as a whole without even discriminating the gender. Thus, Your Lordship, in the POCSO Act was so against the tribals, they would have exempted the tribals, but they are not. Thus, Your Lordship, the intent of the POCSO Act is to protect the people or the minors. Thus, Your Lordship, the POCSO cannot be challenged. Your Lordship, petitioners also mentioned that Abahu was the leader. No, Your Lordship, Munna was the leader of the tribal community, which itself mentions that Munna have that mental capacity to understand whatever he must do. Your Lordship, the council ends with the sorry. President, we have your debate. We start by 11:30, and please report it separately. Actually, but Good afternoon, ladies and gentlemen. As we gather here for the grand closing ceremony of the 22nd TS Venkateshwara Iyer National Book Competition conducted by the Government of Ernakulam, we reflect on the intense arguments, the sharp legal minds, and the unwavering spirit of advocacy that have defined this event. Let's begin the event with a silent prayer. Everyone, please rise for the sign. Thank you. Please be seated. Over the past days, we have witnessed some of the brightest legal aspirants engaged in thought-provoking debates, showcasing their research, reasoning, and original skills. Now, it is time to celebrate their achievements and acknowledge the efforts of everyone who made this event possible. I am Teresa, and along with my fellow MCs, Deepika and Abraham, we have the honor of guiding you through this afternoon's proceedings. Without further ado, let's begin with the welcome address. To formally welcome you all, we invite Ms. Alvia Ajit, student coordinator, to deliver the welcome address. Good afternoon, honorable judges, principal, esteemed dignitaries, and respectful faculties, and all my new friends. It is with an immense pleasure and deep sense of pride that I extend a warm and heartfelt welcome to each and every one of you as we commence the valedictory ceremony of the 22nd TSV National Book Competition 2025. We have reached the culmination of the 3 days of rigorous legal debates, insightful arguments, and legal commentary. We are profoundly delighted to host every one of you as we open the 150th year of Government Law College Ernakulam with its unparalleled excellence in legal learning and shaping countless legal luminaries. Considering this auspicious 150th year, we have invited an array of judges who have stepped in their legal journey in the 2 steps of Government Law College Ernakulam. Today, we are honored to have with us a constellation of legal luminaries who have raised this occasion with their presence. First and foremost, I would like to extend a very warm welcome to our principal, Dr. Vidya ma'am, a visionary leader who have continuously guided our institution towards excellence. We wholeheartedly welcome you, ma'am. Now, with great respect and joy, I welcome the Honorable Mr. Justice Viju Abraham, Judge of the High Court of Kerala, to the valedictory event of the TSV National Book Competition. Mr. Justice Viju Abraham is a respected advocate. He served as a senior government leader in 2016 and was sworn as a judge of the High Court of Kerala. His profound legal acumen and the insightful wisdom have shaped countless lives and strengthened the foundation of our legal system. We are immensely fortunate to have your guidance and presence for this prestigious event. We welcome you to this valedictory ceremony, sir. Now, we are deeply honored and absolutely delighted to have with us today our alumni, Honorable Mr. Justice M.A. Abdul Hakim, sir, a distinguished judge of the High Court of Kerala. Completing his LLM from Government Law College Ernakulam, he began his legal journey in 1992 and was sworn as the additional judge of the High Court of Kerala in 2022. With an illustrious career specializing in civil, criminal, banking, broadcasting, and labor laws, Justice M.A. Abdul Hakim serves a remarkable contribution to the legal landscape characterized by his intellectual rigor and a steadfast commitment to upholding the highest standards of jurisprudence. We are widely recognized and admired. We extend a most heartfelt welcome and express our sincere gratitude for your presence and in this auspicious event. Now, it is with immense honor and profound delight that we welcome our esteemed alumni, Judge Honorable Mr. Justice Shyam of the High Court of Kerala to gaze our valedictory ceremony. After completing his education from Govt College, Ernakulam, Sir began his legal journey in 1996 with an illustrious career specializing in advocacy and shipping laws, commercial laws, and corporate laws. Justice Shams's distinguished career, marked by unwavering dedication to the principles of justice and a profound understanding of the law, stand as a beacon of integrity and wisdom. We are truly privileged to have such a luminous presence gracing this significant occasion. We are also grateful to our dedicated faculty coordinator, Srimati P.S., Associate Professor, Dr. Law College, Ernakulam, and Dr. Jyoti Bhaskar, Assistant Professor, Dr. Law College, Ernakulam, whose tireless efforts have ensured the smooth and successful conduct of this competition. This competition has proven to be a platform where the brightest young legal minds from across the nation has showcased their talent, dedication, and passion for the law. To all the participants, I extend my heartfelt congratulations. Your dedication, hard work, and intellectual powers have made this competition a resounding success. You are not only demonstrated your legal acumen, but also the ability to think critically and argue persuasively and uphold the principles of justice. I will extend every presented here to this valedictory ceremony. Now, I would like to welcome Advocate B.T. Girijan Sir, PT, Vice President of the PT of Govt Law College, Ernakulam, to this valedictory ceremony. I will also like to extend our heartfelt welcome to Mr. Naveen K, Chairperson, College Union 2024-25, to this valedictory ceremony. Now, I would like to welcome all the teachers who have constantly guided us throughout the conduct of our competition. It is also like to welcome my co-coordinator, Ms. Maya, joint coordinators, and all my dear committee heads. My deepest gratitude to your exceptional leadership. The success of this competition would not have been possible without your tireless effort and unwavering dedication. And our volunteers. Thank you from the bottom of our heart for your incredible dedication and hard work. Throughout the competition, we are truly grateful for your contribution for making this event a resounding success. I welcome each and every one of the volunteers to this valedictory celebration. On TV, I welcome you all to this momentous occasion on behalf of Govt Law College, Ernakulam and the organizing committee of the 22nd National MOOT Court Competition 2025. Thank you all.
Thank you, Ms. Nalvayaji, for your warm words. Next, invite Dr. Vidya Nambiya, Principal, Government Law Office, and more importantly, going back to the presidential address.
Honorable thankful judges, distinguished dignitaries, colleagues, participants, and my dear students, a very warm good afternoon to one and all. It is with immense pleasure and pride I am standing before you in this valedictory function. As we are celebrating our 150th year, our college has started in 1874. It has been a long journey, about 150 years. It's not something which every college gets. It is our pride and pleasure that we can say that we have been this legal education throughout all these years. And we have created many great jurists, judges, advocates, legal scholars. It is our great pleasure to say that our alumni is in every nook and corner of this world. Throughout all the countries in the world, we have an alumni there. And in this year, as we are celebrating this 150th year, we have been conducting many programs. And one is this, and we have been in this valedictory function. And this occasion has created from the participants as well as all our students a great opportunity to learn. We had many great judges in this our judges panel, and all the judges who have been in this good competition are our alumni. This is something which we are proud to say. All the judges who have been with us. The High Court judges who are speaking out here, they are also our alumni, so they are part of this institution as your host. Whatever you have learned from here, you have to take this throughout your life. Even though you are participating in a competition, MOOT competition is more than that. It is the experience which you are gaining from here. Because you are all going to enter into the legal profession. Whatever experience you can get from here, it will definitely make your journey very easier. Don't think that you have to get a prize in order to get whatever experience you get. It is not the prize which is the end result, but you have performed to your best of ability, and the experience you have gained from here, it will enrich your life as a lawyer, as a judge, legal scholars. It is you, students, that our future of our country lies. So it is your duty to study well, perform, and you have got a social responsibility to make our country the greatest in the world. So I hope that all of you will strive for that. In order to be a country, a very great country, the important thing is there should be a strong legal base for that country. And for that, there should be great judges, great jurists, great advocates, and legal scholars. Without that, no country can survive. So it is up to you, students, legal students, who have to draft the laws, make your arguments, make the social commitment to make our country a better country. And I take this opportunity to congratulate all the organizers, that is our faculty coordinators, me, Shobi, Nina Kumari, and all the student coordinators. Vismaya, I'm not going to say any other name. All the students, they have been working very hard in order to make this program a grand success. And I can say that it has been a grand success. And as we go on, I take this opportunity to say that all the participants have been performing very well. And in advance to the team who is going to win, congratulations. And I take this opportunity once again say that you along with us can make our country a great country. Thank you, JD.
Thank you, ma'am, for your inspiring words. A valedictory address is more than just a speech. It is a reflection of the journey we embark upon. We are honored to have with us Honorable Mr. Justice Bishop Abraham, Judge of the High Court of Kerala. Justice Bishop Abraham obtained his law degree from Govt College, Ernakulam, and began his legal practice in 1996. He has served as a government leader and senior government leader in the High Court before being appointed as an additional judge. May I now invite Honorable Mr. Justice Bishop Abraham to the stage to deliver the valedictory address. Welcome, sir.
Beloved principal of India, and other judges, and Hakim, this is one faculty voting the global master, student voting the understanding, my dear friends. It's really an application for me. It's a here today. I'm part of 22nd National Input Competition for Indian Vegetation and Monopoly of World Cup, especially for the second is being affected on the 150th year of the establishment of this prestigious institution, of which I was a part. I started studying here during 1995, and my beloved brother, one, we were classmates, along with the faculty coordinator, Jomi, and one more judge, President Gopilam, was also our classmate. So for a very class, we can just the High Court happy education for us. My father studied here, so my wife also. So and I very attachment to this college. And whenever I get an opportunity to come to the college and address, I never leave it. So always I have the occasion to come back to the college where we have spent the most beautiful time of our life. And get assured that this time will never come back ever again. As we had competition, the final competition that is predicted, I would say that all the teams participated well. And it was a tough job for us to take a decision. And then ultimately never decide that they will dismiss. So all the best. I congratulate the winners and also the participants for this competition to participate in the competition. I wish you all the very best in your life. Thank you.
Thank you, sir, for your contributing insights. Now, it's our privilege to hear from our keynote speaker, Honorable Mr. Justice M.A. Abdul Hakim, Judge of the High Court of Kerala. Justice Hakim earned his LLB at LLM from the Government Law College, Ernakulam. Enrolled as an advocate on March 29, 1992, he has practiced extensively in the High Court of Kerala and various subordinate courts and tribunals. He was sworn in as an additional judge of High Court on March 22, 2024. May I kindly invite Honorable Mr. Justice M.A. Abdul Hakim to share his thoughts.
It's quite a classmate in the when I was going to be doing I should refer to my classmate who is here or immediately. And my brother is and the really is and the other faculty members and all of them dignitaries of the day. My dear participants and the organizers and dear students. The participants today performed it extremely well. And easy for us to decide the case. But it is quite difficult for us to decide as to the performance of the lawyers. Anyway, as my brother did told very sadly. Moot court competition, moot court. It's a practical training of our legal profession. Every profession needs practical training. Nowadays, all the law students get opportunity for moot court. They attend several moot court and their practical training is in abundance. During the time when we do is intention, Dr. Ginipol, and there were before the judicial councils also. We had only one court competition. That was also done under compression. But nowadays we see that despite of all these practical training, the young professionals continuing in this profession is declining. Two major reasons are change of policy. One is overcrowded. The profession is overcrowded. Second is non-conflict. I would say these, the second reason may be somewhat sustainable, but the first reason I would not say that is a sustainable reason because every profession is the overcrowded. Even this world is overcrowded. Even this world is overcrowded. Still, you have to space to live in the world, and you are sustaining. So you have a space in the profession also. So law students like you should come into the profession. You have a space there. The law legal profession needs you, people like you. Then the second thing is not remuneration. You may see there is a little fact about that. In the initial days, you will not get much remuneration out of the profession. But you see, almost all successful lawyers sustain only on account of the free food and accommodation provided by their parents during their initial days. And almost all of them have decided to quit this profession, including me, at one time or at another time. So if you are able to withstand or overcome the initial struggle, then I would say sky is the limit. So I pray Almighty that the Almighty may give strength to and courage to you to succeed in this profession and succeed in this profession. And there's a business principle. Only when we take more risk, then only the return will be high. I will give you an example. We studied together. She was a bright student, and I was an average student. We did both of the bright student. During these two people got employed. I had no other option because I was not smart enough to prepare any employment. So I was compelled to stick on the profession itself. So I decided to take the risk. That is the only option available to the world. Just like me, my father was an advocate. Her father was also leading advocate. We both belongs to lawyer family. Her brother, my sister. In spite of that, she did not join legal profession. If she had joined legal profession, she would have climbed much more than ever than it that thing. Fortunately, she didn't do it. So I decided to take this. Initially, I had to deal with several problems. Money problem, senior problem, senior my problem, senior problem, every problem was there. Then I got seasoned by the length of time. I looked at all these problems. All problems I was able to convert all these problems into positive. Then the law became a passion for me. Initially, this was not my passion. I was part of the college. I wanted to become a chartered accountant. But when I was possible the entrance examination. Actually, tell me that the entrance examination. When I wrote this, I thought of minimum year. My father is an engineer. So I joined this course. Joined this course. That is how I came to the course. But the moment I started loving this course, the games has become a passion for me. It became a puzzle for me. Then by the experience I gained in this mountain, I have had the experience to deal with the problems in life goes. And I achieved at this level. I still remember when I was sitting there, I never thought I would be standing here as a speaker in my capacity as a good. You also can be. So, so don't spoil that opportunity. Down to this problem. This profession need. That's all. Thank you.
Thank you, sir, for your enlightening words. We are honored to have with us Honorable Mr. Justice Shyam Kumar, Judge, High Court of Kerala. Justice Shyam Kumar obtained his law degree from Government Law College, Ernakulam. He specialized in maritime law from School of Legal Studies, Russian University of Science and Technology. He has also served as an adjunct associate professor in the National University of Advanced Legal Studies, teaching maritime law and related subjects. May I now invite Honorable Mr. Justice Shyam Kumar to deliver special address.
Brother Justice, India, Madam. Brother Justice, Abdul Mateen. Principal Dr. Bindu Dhamera. My dear classmate Joby. Members of the faculty. Student participants. My dear students. I don't think that I need to add anything more, but Brother Justice, Bindu, as well as Justice Mateen mentioned. When you come back to your alma mater, it has a special kind of effect on it. You tend to become frank and honest and start to speak out from your mind, just as Abdul Hakim was speaking out, right from the bottom of his heart. So I guess that it has the same kind of impact on me also. As Justice Hakim was pointing out that he was sitting there in that chair when he was a student. I remember standing very well here and maybe hanging on to his podium with all trepidations and fear and arguing my first move. That was in the final year when move was not a usual thing that happens. As Mr. Sakim was pointing out, we were rather compelled to do 3 moves. One for the petitioner, another for the respondent, and the third as a judge. And the third is the most interesting part because we just have to sit through it. You don't have to ask any questions, we can sit through it. And the third mode is also done. And at that point of time, there were no competitions as such, but there was one competition that was held when I was in my 5th semester. And myself, along with a friend of mine, decided to give in our names only for the reason that the MOOT club secretary was a friend of ours. He said that there are no enough teams, so just we need some more teams. Why don't you give your name? And we gave our names and we started working on it. We never had a library as big as this one that we had. It was a small library over here, which was more like kind of a dungeon, dark and kind of a damn space. We prepared for some days and finally the day came when the vote had to be argued. We lost all of our hope. We were trembled. We decided that we will somehow read out from the paper and escape. So of the 14 teams were there, when our name was called out, I found that my friend is missing. And he was so overcome with fear that he had gone to the Indian Coffee House very close to the OJT and he was hiding there. So some of my, because I was here and the MOOT club secretary went and got it and brought it in. And we somehow, whatever we had to say. And I remember the judges were sitting in the same podium. And a question was put to me. I remember the question even now. It was a move in which I was taking a writ of mandamus. And I was asked, have you approached the concerned authority with the prior to filing of this mandamus? Which I know is a mandate to the children now. Which I didn't know at that point of time. And I said, no, you haven't approached, no, I have not approached. I'm coming here. And when the marks were declared of the 14 teams, we were the 14. I say this because now I stand here and in the last maybe around three months time, I'm coming here for the third time to get a MOOT. And there is a very good possibility that the 14 teams that are like the TSV, the members will be in a maybe 20-25 years standing here and addressing and judging as a judge. Point that I want to make this and Dr. Vidula here are pointing out this. Participation is what matters. When you participate in a MOOT, you gain some experience. You may not realize it at that point in time. I would have to say, even sitting through watching what is happening itself has its impact on you. You know how a person, when confronted with a question, behaves, how he tackles it. How does one think one is on his feet? Because this is a trait that they may have to develop as a lawyer. Many a times in a court, you have to take split-second decisions. You may have to take turns and come up with a novel contention when you are suddenly confronted with some point that is being thrown at you by the court or by your counterpart. So that essential skill to think about your feet is something that you can develop even during your legal education times by participating in MOOTs. The second aspect is the skill of thinking analytically. Now, you should understand that there is no syllable or a term or a punctuation in a MOOT problem which is there without some intention or without some purpose. Every word in a MOOT problem is there for some reason, and the problem setter or the maker of the problem intends to convey to you some aspect which you need to take note of. So when in this case it is said that the boy, his name is Mona. Mona has other relationships with few other girls. It is there for a purpose. That opens up his task to argue on his character, his conduct, his personality. So that is one more avenue that has been left open for you to work on, think, and develop your conclusions. So as a person who had opportunity to set more problems myself, I found it to be a very tough task. So as to collate together different aspects and put across to the students areas where they may be able to work and also ingeniously create them. So what is being looked at by the judges in a MOOT competition is essentially how ingenious you are, how analytical you are, how deeply you are worked on the subject, not the correctness of your answer. So when a question is being thrown at you, we don't expect a correct answer. We are trying to ascertain as to when confronted with this, how does the individual behave? How does he tackle the situation? How easily or quickly he or she comes up with answers which are logical and substantially related to the question that has been posed. Or more importantly, is the person evasive? Are you evading it? Once you evade it, it has a telling effect on the judge immediately. And the judge remembers If you say that I will come back to it, or your co-counsel would speak on it, and that is usually a very natural way of avoiding it. But still, that registers in the mind. And if you come back to it later, the kind of impact that in your frame that will be there in the mind of the tape will be substantial. Your mark is rigorous, to the extent that she will come back to it. She has come to that very aspect again, and that has done it. So on the left side to the right, as it was pointed out, it's a tough task for us to decide between these two teams. It is a very perfect margin for wasting in the final round because you have passed through so many rounds that it becomes difficult to make out the best among the best teams that are there. I congratulate the winners. I congratulate all the participants mainly for having participated. I hope that all those students who witnessed this event would be enthused to participate in the board simulation. I congratulate the German Law College of Ernakulam, the faculty members, and all those volunteers for having put together a wonderful job. It's not an easy thing to put together an all India. They have done a very good task. I congratulate each and every one.
Thank you, sir, for your valuable perspective. Now, the moment we all have been waiting for, the prize distribution is complete. It's time to recognize and celebrate the hard work, dedication, and brilliance of participants. We request our student dignitaries to carry the honors of presenting the awards. Remember, the smartest teams from all over the country have listened to Kochi for the coveted 3-day TSV World. This is the 22nd edition of this prestigious workout competition. So most of the experienced faces you see around here were once participants or coordinators of this event. So to all the teams that couldn't bag a prize here, remember you are becoming a part of history. Your names will be etched in the annals of this competition. So first, to give away the participation certificates, let me invite our principal, Dr. Vidya, to point. And as the names of the teams are announced, please come forward to receive your certificates. First participant, Kannur University, Department of Law, School of Legal Studies, Manjeshwaram campus. Please come forward. After the sleep awards, please wait a moment here so that you get a good snapshot. Next, CSI College for Legal Studies, coordinator. Next, campus docent, faculty of law, University of Delhi. Symbiosis Law School within. And the semi-finalist, Tamil Nadu National Law University. The participation received whereas books sponsored by MVP House and RBPL Books. Thank you. And please seem to be kindly seated. For the next category of awards, let me invite to the forefront Honorable Mr. Justice Shyam Kumar Median. Here we are recognizing the best researchers. Remember that researchers gave us solid competition to and MOOT team. The person's more like Batman, they operate in the shadows. So our judge could reveal the names of the third best researcher first.
The third best researcher is TSV 131.
The third best researcher would receive a takeaway trophy and a cash prize of rupees 5,000 sponsored by the Board Club of University of Dhaka. I request to notice the photo on your left. If you like, get your left hand to get a place. So, now, the second best researcher.
The second best researcher is TSV 129. Martha Nayak. Hello, here of technology. Allow Martha Nayak. Yeah, okay.
We have a series and ever online shopping sponsored by Board Club of GLC Ernakulam. A takeaway shopping and a cash prize of rupees 10,000 sponsored by Board Club of GLC. Meanwhile, a gentle reminder, everybody who receives advice, please make sure that you look forward to the camera placed on your left. So that's where the official photographer takes the picture and not on the tripod. Now, the best researcher.
The best researcher is TSV 103.
The best researcher industry general property and ever owning property. Also, I can bring the one and warranty. And cash price, rupees 15,000, one lakh GST. Thank you, Shyam sir. I'm going to request you to be seated. For the next set of hours, let me invite to the forefront Honorable Mr. Justice N.A. Abdul Hakim. We are giving away prizes of the best, second, and the third best memorials. So, at first, the third best memorial. The award shall be revealed by Honorable Justice. As the names are called out, all the team members, please come to the forefront and face the camera. Fix on your left.
Best Memorial TSV 134. Symbiosis Law School of India.
The winner shall please receive the takeaway something and in total a cash prize of rupees 5,000 sponsored by Boat Club GL3. That's all. Now, the second best memorial.
The second best memorial PhD 135 goes to R. Gregorius College of Law and
The second best memorial. The team shall receive a Boat Club of GLC and out of electronic shopping and take away from each and a cash prize is 10,000 sponsored by Boat Club GLC. And we remind them to please take the camera on the receiving award. Now, the prize for the best memorial. The best memorial should receive an ever-rolling trophy like Moot Club of Government of Ernakulam, MC Matthew Memorial, ever-rolling trophy instituted by Advocate C.D. Matthew from KLT and Anand Krishna Memorial, ever-rolling trophy. They shall also receive a takeaway trophy each and a cash prize of rupees 15,000 sponsored by Moot Club of GSAVS, Advocate C.D. Matthew from KLT and Anand Krishna Memorial first.
best memorial PhD 143 goes to Windows Law School Noida.
Thank you, sir. I now request you to kindly seated. Now, for the next batch of robots, let me invite to the forefront Honorable Mr. Justice Viju Abraham. The next category of award is for the best speaker, the face of the new team. Hospital arrangement and carefully placed bets. Being witness the future roaring aggregates and action. So I have the request from the justice to reveal at first the third best speaker. Third best speaker, TSV 121. Somebody. The third best speaker is received by Elgin Company at a cash prize of rupees 5,000 sponsored by both the government corporation and our. I request the winner to go to the other side and fill in the counter. Now, the second best speaker. Everyone kindly know that our camera person is positioned to the left of the judge. So whoever comes and receives the prize, please face the camera in order to get a good reception. Second best speaker is being on the team. The second best speaker will receive a take on the trophy and a cash prize of rupees 10,000 sponsored by Youth Club, Government Operation and Power. Now, the best speaker. Speaker, TSV 132, Ahmed Kumar. The best speaker, the Ishwara Iron and Memorial Economic Shopping, instituted by Justice Ishwara S. Takeaway shopping, one by Bokla, Shilpan, and other work on different closed memorial. One have also received a cash prize of rupees 15,000, sponsored by Justice Ishwara S.
So we can, like,
Justice Simon Thomas.
okay.
And we can fetch you period. Other economic from Pink. We have Thomas Memorial Economic from Pink. It links to the right, Justice Simon Thomas. Economic from Pink is given by Chandrasekhar and Chandrasekhar and Associates. It is Joseph Memorial Economic from Pink. It's given by now 8 of that. Take the bets on being sponsored by both clubs, government operation and Ernakulam. Take the bets on being using metals. And cash price of basically 3,000 also each one has. That's this civil office. Advocate vegetarian office. Shaker and associates. And it costs 8 to 30 for your batch. And another ever-rolling trophy sponsored by GSC Ernakulam Alumni Association. For the last scheduled award, I want to request all the dignitaries to come to the forefront and join the gift award. As always, the next category forwards is for the best team and the first and second runners. First, we will announce the first runner. I'm sorry, second runner. Second runner is Shastra Dean. With team, it's a simple confidence set. The second round shall receive Dallas Empowerment Memorial Ever Knowledge Trophy, instituted by the 2012 batch. The team should also receive and take away trophy in joint and for each as well. The second round team receives a cash prize rupees 10,000 sponsored by both the TSV and Bangla and the rest 2012 and 15 batch. Now we're breaking convention here. We have expected us to go forward with the first round team, but not to break the suspense. We'll be going for announcing the best team here. That is the of the legal minds in our country, I would say. So, the best team, the winners of the 22nd GS Venkateshwara Iyer Memorial MOOT competition hosted by Govt Operation Ernakulam. I request Honorable Judge to announce the prize. And you know, it's TSV 155.
The biggest football memorial ever product property. It is by power of cases level balance. I don't get fix the modern memorial ever product property. We will forget property. And now the product property ever product property. We will buy it. I think it is part of that. Both clubs are professional operated and not ever like one. Database topic, what is common to indicates and what is to members. The house is sponsored by MCP House and other campus. The winners share the same and cash prize rupees 30,000 sponsored by Advocate Rajesh Sagar, Senior Legal Advisor, Kuwait Airways, and Govt, Legal Advisor to Kuwait. That's why the office of as Secretary to the Advisor, the office is level that's got cooperate with the partner. The office of Secretary may speak to the qualifier, Advocate Maros Dr. Gomagan, and the board of the operates the partner. Thank you. Now, the board members. I request the justice to review the minute. The paper receipts. Everyone was topic is sponsored by both club of government operation and Mangala. Tamil Law Society pursued everyone topic. Take the best topic, one for the team and one each for participants. Sponsors are MPB House and Aditya Books. The first member of the thing, a cash prize will be 20,000, sponsored by Bolson's not innovation and sometimes also by Jacobs. One word to this, I now I complete this, our principle to give to our justice honor, a token of our love and appreciation.
First to Honorable Mr. Justice Shyam Kumar PS. Next to Honorable Mr. Justice N. Abdul Hakim. Another token of gratitude to Honorable Mr. Justice Visual Abraham. Thank you, ma'am. So our prizes have already been announced, and kudos to all the winners. A gentle reminder to all the winners to return the enrollment office to the concerned authorities. You can take the takeaway office and everything else. So there's one much awaited moment waiting. I humbly request the winning team or and one member of the winning team to give a return speech. I invite the team just come was getting a lot.
So hi everyone, I'm Govt. So this TSV was my first move. And to be fair, I think what happened the last time was we were out of the films. Yeah, myself and Ashwini, our first move was this move. And coincidentally, we believe that this should be our last move since we were in final year. And we are happy we got to take the best team home. And I don't know how to express because I'm so happy right now with being final year. This is the final year of my college. And both of them happened. Three of us made the best team ever. Because I'm happy to got to share this moment together. Even against the end of the picture in the college life. I was honored to receive the best team from the honorable judges. And you know what I have to say right now, because this was my first move. I've judged all the moves I've done till today as per the standards of TSV move. Because the last time we came here, it was the best experience ever. And one more thing before I forgot to mention, I want to say that we got the best license here, such the best example of how a license should behave and how responsible a person should be. Sakshu put a message in our chat. We could take the cut home as well when we pass the prelims, and I believe we can show now as we achieved it. Really thank you for extra this moment together. I'm more happy to share with both of them. And we are telling you what I to say. Thank you.
Thank you, Sam. So what said and reminder. So after the board ceremonies over, as I've already mentioned, we have to return the award trophies. Before that, we will be taking your pictures with all the enrollment trophies assembled together. So after that, you need to return the prizes. Hope that's clear.
As we near the conclusion of this grand event, it is time to express our heartfelt gratitude. To deliver the vote of thanks, may I invite Dr. Joby Haskell, faculty coordinator. Let's move.
Respected principal Dr. Victor Lamia, esteemed judges, possible visual Honorable Mr. Justice Shyam Kumar, Honorable Mr. Justice Abdul Hakim, PTA Vice President, Just Sir, faculty members, academic attorneys, dear participants, and my dear students. Good afternoon to all. I don't want to violate human rights, like food. I will come in as soon as possible, but still, since we started it for the last 2 months, it is not my easy job to vitally reach one or two things. Okay, so with our faculty coordinators, Srimati ES, I am honored to represent my team and express our collective appreciation. After the 2 months child of efforts, when we organized the 22nd National TV Federation National Football Competition 2025, we have witnessed fierce arguments and intense deliberations among all the teams, and I congratulate all the winners and participants so for their outstanding performance. As we celebrate the 150th year of our institution, we take immense pride in our colleagues' own legacy. The presence of our principal, Dr. Vindu Ernakulam, who has had an illustrious academic journey in this very institution, is a testament to this legacy. She did an LLM with and passed with rank, LLM here with passed with rank, and she also did the PhD on it. So I didn't know the person can represent the 150th year of leaders in this 150th year, and we are so grateful to her to be here. And her leadership and vision inspired us to organize this competition, and we are grateful for the unfailing support and guidance. Thank you. And whenever I organize a program over here, I just for those to my classmates groups. So whenever I organize the first call was to Justice Viju, and he always accept it and he stay over here and raise his occasions and not taking too much time. Thank you, thanks a lot. And also my another classmate, even before he became a judge, since he is such an expert in maritime law, and whenever I take insurance law, I used to call him to take a class on marine insurance because he is such an expert on that topic, and he might have thought that he might have escaped from that, but no, after he became judge, then I started calling as a judge to grace all the occasions I used to organize. So thank you, Justice Shyam, for coming and delivering our program. Justice Hakim sir, since he is underclass, he's also trapped over here. President of President of Hustle. So no excuse me too. So whenever he calls, he raises the situations. So thank you a lot. And I would like to thank Govt, our alumni association, whenever we see any they used to come over here. And in the presentation also, Shinsi ma'am raised the questions and delivered this presentation speech. So thank you very much. And another committee or association which is integrated with our colleagues is none other than PTA. And whenever there is a call, Indian service always go to help us. So special thanks to Indian service. He is our okay. And I would like to thank all the judges from the very beginning of all the judges, judges who acted as judges and quarterfinals, semi-finals, and post-finals, and 64 judges in Jordan, High Court judges, as the principal man has stated, all and that is what we meant by the record. And so it's a very great feeling to say thanks to them. There's no need to thank them because they are part of all this. And one more thing I would like to disclose, which is not disclosed by anyone over here, that is the MOOT proposition is also prepared by one of our classmates along with and the Franklin persons prepared this MOOT proposition is Jean Miranda Peter and Mr. Helico. This complicated MOOT proposition which help you to burn your brains. So thanks to them. And I would like to thank the sponsors because you know that this is a government institution and it's what difficult to run such a glorious prestigious program in this institution. So we have too many sponsors and I would like to thank TVS Regulation and Office, another classmate, Advocate Rajesh Sagar, Senior Legal Advisor, White Airways, and also Knockout Legal Advisor required. Justice Ishwar S. Advocate C.P. Matthew, KLT. Justice Bechu Korean Thomas, Justice Korean Thomas, P. Subramanian Associates, Chandrasekhar and Chandrasekhar Panel Associates, classmates of Jaji, year 2012, 15, classmates of Pravi, year 2008, 2011, classmates of Living Joseph, year 2008 to 2013, and the Vishnu Trust, Samanda Law Society, Costa, our Annual Association, Rajesh Gopal's brother, Advocate Manoj Rajagopal, Advocate Alan, Aditya Books, MPB Publishing House, and all those alumni who acted as judges in the competition and contributed their honorary to this competition. Thank you all. And finally, the stars of the competition. Without whom this competition is nothing. That's our participants. Each one of them has actively participated and making it a great success. And as I told you, without it is not at all possible. The enthusiasm and vigor you have shown is really appreciable. Thank you once again. And our teaching staff, our faculty coordinator, joint coordinator, Srimati Inamani, as Dr. Priya found, they are always looking to do what they are doing, anything to do, always they are asking and we are doing it always there with us. Thank you, both of them, and all other faculty members behind us, see, especially our younger generation. Dr. Shinsi, Parvati, Vani, Alina, Mohammed, Mary, Sri Lakshmi, Rajeshwari, Vicky, always good throughout all, whenever I talk, for times, very much for supporting us. And all the non-teaching staff, especially our cleaning staff, always for 4 days, we are continuously going to 7:30 to 5 hours, it's always the and also our DS training. And thanks to College Union and the leadership of Chairman Mr. Govt, their support was always going to organize this program. And now moving on to, I don't know whether I have to thank them especially, but I'm thanking them. Volunteers. Without if I even think of what we can each, that's the thing. And at that moment, I realized I know nothing. Even if I am a faculty or if you know, but in order to organize a program or video, without my students, without this volunteer, what we do? Nothing. We can't do anything. So you are the strength and the real force which help us to run this function. I cannot name them because there are around 250, 300. So I cannot name them. Sorry for this, but thank you. That's a lot. All these volunteers, it's a pyramid. So for each volunteer, there is a head of the committee. We have around 15 committees. And I name each committee heads. That's my, with great pleasure, I am thanking them because from the day one onwards, they are being, what is it, they're funny. Actually, most of them not even getting in time to sit. Sometimes we say that, come, please, sit here. Then we talk. No, man, this, listen. Okay, that is thing. Please sit. That we have to command them sometimes to sit. Sometimes they forget to drink water and get dehydrated. That is the situation. That much dedication shown by our heads. What else I can say to them? They are always looking in my our stuff. And as I told you, our proposition is done. There is both of social media startups. They are customers. She is always there with her volunteers, but volunteers were very less. That's the so almost it was on that show that we got to their Krishna for the whole like the whole India. And another team, which is 2 points, but I think they reached around 170 or 180 coordinators daily, coaching them, calling them, all the updates, next days in London. Very good. That can be very quiet, I'm going to better, but she is doing a job perfectly well. The work of another person registration. She's calm, but no. Not that. Ishma, St. Children's. Okay, Grishma. 24 into 7 is not enough over. It's always the time doubling it. I'm doubling it. Whenever I see, I can see some benches are the, I can see someone pregnant. Some Sunday evening, Saturday evening, or evenings. I think she's giving that action is to the volunteers. To thank you, you are really thank you. And our shoulder, she managed to that shoulder. But movements to ABFC, and shoulder. That's like the I think I was and so that is reflected through volunteers. So one team has the appreciation is the one of the volunteers born eligible to get that appreciation. That you actually do it. So the next person, our trophy committee head. That day I feel a lot more. He said that no, I won't be able to do that. But then I said, okay, there's an end of it. We have no relation from today onwards. Then he said, no, I can. Our footballer, Mr. Conway, there are some other ways to go along with that, but I'm not taking it because it will be some equality is problem. So just because of that, I'm not taking saving and name which comes with the certificate is only have to travel up. That's why. Okay. Okay, so thank you. In between, they went to play football because the last week we are having football match and he is so mad for this football and he's dehydrated and fell down in the ground and still he came even in. Okay, now I'm okay, do the next. That's the thing he has shown. Thank you. Thank you. Another girl, sometimes I forget. But she's my daughter Neha. Because I started loving her like just like my daughter, starting love. And I'm just and that time I also want to add one name with that by teaching the principle of equality, that's the rich. Towards not even a word of anger, fear or tension, nothing. Um, the thing is that I never know that she's such a got first. You can talking about being loved and own punishment. It's a tough job because the real person who comes into contact with the judges and it's headed by another little bit special lady. Come here and see you. Honestly, I think she can be my successor because I used to be always have a text field. Look, like what is she's like is times. My complaining is big is that doing is buying is twice. So I guess that Kavya too, she managed the talk very well. That in fact is I know that this getting a big intended, but I have to do this. Sorry. Don't take it and using it. That you have to. Um, next. Obviously, when we were discussing about who we elected the retaliation, because this is the thing we have to announce that we go to. So we be the person should be calm without taking any intention. And the name came up is Badriya. Why? But now again, I think I never did that she had. I really doubt. I confess actually, I really doubted whether she had that leadership quality. But at first, she was always everything. Yeah, also I require quality right. Cost. I can the team, the whole team. Okay, sorry, it's not that, but I'm appreciating the intent of the whole team. And next one is our technical. Not here, Jimmy Matthew from the deputy, because the training round, it was full online. So many issues, this is a government institution, again, the teaching, the Wi-Fi issues, everything, and the court has to be function for this. And today also, there is YouTube live is there, so for everything, the Jimmy was there. Thank you, Jimmy, for listening. Thank you. Without food. without food, what is in the case of this balance, what is even if everything is the doesn't have food, what's the use? So food committee help just now. Uh, I pay your pay, thank you, serving the whole public. Thank you. Then the accommodation and accommodation act was often the of all of the students and hotel restaurants and hotels and quite comfortable for the participants that we like to know maybe and transportation I might have here. And don't worry about the participants I take care of it. So whatever you hear, whatever happens, don't worry about it. I will be there. The participants will reach on time. So that is word. To become agent because they have to be sent back the budget. Till then, the activities were solved. Okay, thank you very much. And it became the fund choice and Chandra in there along with Piramid. So thank you for yesterday in a beautiful evening. Cultural invite you on the always. So thank you everyone. And finally, the person whose work started from today onwards, that is our Matthew S. Thomas. Finance head. It was down. Until we get it clear, the finance thing, everything is get the bills clear, audit objection, it's clear, no working term, till then, thank you. Okay. So that's how we think in the marketing, really last year. Trying to do last. First, when I went August, even though it was student, but the beginning and is so quiet. And being head of a program committee that has the top work that is, I was getting afraid of what it was saying in business practice. We wrote, they can be everything. It's not taking any work and playing football. Usually it is leg, kicking, riding the bicycle because no one else is there to help me because all the volunteers are in the football ground. Now he is holding the first event along with that and he did everything perfectly. And we have to, when we organize it, to used to be with coordinators from the final years. But this program has to continue, isn't it? That is why it's called legacy. So we have two vibrant joint coordinators who will carry this practice to the next level. That is Minately Berlin and Joint Secretary. When I joined this Congress in 2021, within 2 or 3 months, our principal requested task to organize a MOOT. And I don't even know about any students, I not in contact with anyone. Then we organized it with the help of the test coordinators, Nandini, and Maria, and Shiva, and Joan Family. Then the next year also, she insisted that we should have an offline event. That was an online event. And she insisted that we prepare the of 5 years, Aisha Ruswana and Abhinav Kirmeni as our coordinators, and this Aisha was always saying, yes, minister, whatever you say, yes, whatever you say, I will never say I can't. So that was the way I used to have. So when we think about who will be the coordinators for this years, then after discussion, we got two extreme poles. One is too far, the other one too high. So one is our idea and another one is very. They take their job perfectly well because they take care of each and every aspect, and they are the top of the pyramid, and they were there always with us, and they did their job, everything, and fit into places, everything is okay. So thank you, both of you, for being there and continuing the legacy of the National Report Competition 2025. And I extend my thanks to all the media, light and sound, and if I miss anyone, it's not intentional. And it was pretty long fun, so thank you, thanks a lot. And as we conclude the 22nd year's Venkateshwara Iyer National Football Competition 2025, I extend my heartfelt gratitude to the divine forces that have guided us on this journey. Thank you, thank you.
Thank you, Matt, for your kind words. And with that, we come to the end of the 22nd National Football Competition. It has been an incredible journey filled with intellectual rigor, legal acumen, and inspiring camaraderie. A big thank you to our esteemed guests, participants, judges, and organizing committee for making this event a grand success. To all and legal minds present here, may you continue to argue with passion, reason with wisdom, and pursue justice with integrity. We hope to see you all again next year. Now, I request all of you to kindly rise for the national anthem.
Everyone should close here. Please, remember that we have arranged lunch for everyone. So it's traditional.